Can't put them properly. They're all over my thing. No problem. Mr. Ponyan? Mr. Ponyan, where is it?
Worship, I see the defense on the other side is not ready. Can I have all this?
Yeah, let's do our postponements quickly.
Thank you.
For our court first. Oh, Nikiba, you want to start with interpreting the affidavit again. After the argument, because
Makumbi se Roberto Makumbi se is out of bail. But Roberto Makumbi se Advocate Kumar is on record in this matter. That is the reason for that was the
where is me? It's Kumar.
Advocate Kumar, oh, Mama Zubanga.
Where's the counsel, sir? Go call him.
Because the matter to stand down, Mboro. Katlehong. Mr. Reneke is on record in this matter. Mr. Reneke would like to address the court. His client is absent.
Yes, Mr. Reneke.
Morning, Your Worship. Your Worship, I was informed by my client that he is ill and had to undergo an urgent medical procedure. He was admitted on Friday. He is now in court. It's in the hospital. It's in the Wits Donald Gordon Medical Center. I can, for now, hand over these documents. That's all I have at my disposal, Your Worship.
And it was for investigations, Ms. Malo. Are they complete there? Remember you postponed for investigations. Something was
It was for further investigation. Your Worship, that has been attended to. Investigation is now complete.
Date then?
The 5th of September, Your Worship, request a warrant to be held both until then.
Is it 5 September? The warrant of arrest is authorized. Bail money provisionally forfeited to the state the 5th of September. The date of return is the 5th of September. 5 September then for final orders.
That's a good business, Your Worship. That concludes my role, Your Worship.
You're excused to enjoy your day. Thank you.
Bongani, Malcolm Sitole, Bongani Mkwanazi, Vusumuzi Hatebe, all accused persons on bail. This is a worship of the accused persons represented by Mr. Mbunjana, who is absent. instruction.
Thank you, Your Worship. I do confirm my appearance, Your Worship, on behalf of all three accused persons, Your Worship.
Are you on record, Ms. Bogare? Oh, yes, you are.
No, Your Worship. On the previous occasion, I did come on record, Your Worship.
But now?
Pardon, Your Worship?
So you're on record?
Yes, I am, Your Worship.
Yes, instructions. Now where are we going with this case?
Your Worship, court's indulgence, Your Worship. Your Worship, defense has not yet received copies in this matter, Your Worship. What's not for copies today? Today.
Ms. Baloy, copies?
God bless Your Worship. May the matter be
Will you give it to Mr. Bunja and show?
Yes, I did give it to him.
Not postponed for copies?
Yes, Your Worship.
Date?
Mr. Mumukane.
Indulgence, Your Worship. Application to approach, Your Worship.
And now? What's happening?
Thank you, Your Worship. Your Worship, defense is suggesting the date of the 30th, Your Worship, for copies.
Oh?
Copies, Your Worship.
Next week?
Yes, Your Worship.
No objection, Your Worship.
Gentlemen, then for copies, we give it to your attorney. You're on bail or bail is extended half-past 8 district court number 3. If you don't come to court, one arrest authorized against you 30 August, half-past 8 DC3.
Thank you, Your Worship. Provisional excuse.
Mohammed Chunaka. Mohammed Chunaka is out on bail. Mr. Mahokar on record. Mohammed Chunaka. Members, please assist. Mohammed Chunaka. Thank you. Court pleases. Mr. Mahokar on record. Matter postponed for outcome of presentations. No outcome today, Your Worship.
Yes.
Yes, thank you, Your Worship. Your Worship, we do confirm same, Your Worship. Your Worship,
Please rise, Baba.
Ms. Baloy, you look so confused. Are you okay?
No, I am okay, Your Worship.
It's a Monday, ne?
Yes, Your Worship. Further so, Your Worship. Your Worship, we did attempt to submit representations to the SPP. However, Your Worship, he informed us that he was not in a position to consider same, Your Worship, as he was not in possession of the docket, Your Worship. So in open court, Your Worship, we did submit today, Your Worship. So we may postpone for the outcome, Your Worship. Suggesting the same date, Your Worship, I think it would be sufficient to postpone the matter to the 30th, Your Worship.
30th it is, Your Worship.
Representations outcome then say you're on bail. Your bail is extended half-past 8 district court number 3. If you don't come to court, one arrest orders against you 30 August, next week Friday.
Nguni Tusi. Nguni Tusi is out on bail, please. Members assist. Nguni Tusi. Mr. Mahukari on record his client, Your Worship. Maybe he knows his whereabouts.
Your Worship, thank you, Your Worship. I did speak to the accused person, Your Worship, about 10 minutes ago, Your Worship. So I don't know, Your Worship. We'll leave it in the hands of the court as to
So
whether
he's
the court
not here?
He's not yet here, Your Worship. He told me that he was going to be here in 10 minutes, Your Worship.
He's on bail.
Yes, Your Worship.
So we do the 14 days, want me to stand it down?
14 days,
No
Your Worship.
pressure.
Pardon, Your Worship?
You can stand it down or want me to do 14 days, no pressure. Because you say it's on
14
his-
days, 2nd of September, Your Worship. Final forfeiture of payment.
You let him know of the date, Mr. Mkhokare.
Pardon, Your Worship?
You let him know of the date.
Your Worship, I'm not hearing the court.
I'm saying you will let him know of the date then.
Yes, Your Worship. As well as outcome, Your Worship. Same with this matter, Your Worship. It was for outcome. In open court, Your Worship, we're submitting the representations.
The warrant of arrest is authorized, then bail money provisionally forfeited to the state 2 September for final orders.
Indebted, Your Worship, my role may be excused, Your Worship.
Excused, enjoy.
Thank you, Your Worship.
Yes, Miss Malo.
State recalls Roberto Mangumbise, Advocate Kumalo on record, Your Worship. Magenya on the
Yes, Mr. Kumalo.
matter set on issue for purposes of plain trial. Witnesses absent. Entry by the captain is that I.O. is on leave. Only coming back on the 6th of September. Subpoenas could not be served. State request final remand for purposes of plain trial.
Morning, Your Worship.
No, Miss Kumalo.
Your Worship, I confirm appearance on behalf of the accused here, Your Worship. Further confirm matter was remanded for plain trial today, Your Worship. Your Worship, at this stage, there shall be no objection to the matter being remanded once again for plea and trial in small places.
Wait then.
May the court's indulgence, Your Worship, to Your Worship, if I may request the 23rd of September, if it's in order with the court.
No. The day before public holiday. No. Court is not sitting on the day. No.
Your Worship, for then, the 30th, Your Worship,
Of
September.
that I can do.
So as to give enough time, Your Worship, to the state to secure the attendance of their witnesses, Your Worship. I'm requesting, Your Worship, that the accused bail be extended as court pleases.
30th it is, Your Worship, conclusions.
Mr. Kumalo,
Thank you, Your Worship.
you got the notice, ne? About robing.
Correct, so Your Worship.
You'll be required to robe as well.
Will do so, Your Worship, as court pleases.
30 September, then for your trial, Mectors Mark final. You're on bail. Your bail is extended 8:30, District Court number 3. If you don't come to court, one rest orders against you. Thank you.
Bongani, Baren. Bongani. Out to the morning. Bongani, Baren. Matsuland, Your Worship, is on record in this matter. A transfer from DC to Justice with now. I don't know whether my learned friend Your Worship is willing to wait for me to make copies for him or rather postpone the matter for a future date. But he did indicate to me that they also have representation for consideration and perusal of the SPP.
Good morning, Your Worship.
Good morning, Mr. Magnan.
I apologize not to come and greet the Honorable Court.
It's all right.
Thank you so much, Your Worship. This is the first appearance before Your Worship. And we are requesting the contents of disclosure. And then I'm handing a copy to the state. And I'll request the state maybe just to sign a copy for us. And then we are not in a position to proceed with the trial. Although the charge sheet is indicating that the matter is trial ready. And then because we have not been favored with the contents of the police case document. But I can say that my colleague is busy, and then maybe she should be allowed opportunity to make copies, and then so that we can collect them in the next appearance. And then
so you don't want the matter to stand down. So you can make copies for
I think we'll come next time. I'm just rushing elsewhere, Your Worship. I apologize for that.
The date for copies then?
Then let the state maybe propose the date in the sense that
Any date that is a Monday, it's fine.
Any date.
That is a Monday.
Private attorney's Mondays, legal aid is not here, so
okay.
It's easier.
Are you preferring the first Monday in the
any other Monday
in September? Just a bit, Your Worship. That will be Monday the 16th of September, Your Worship, if it's available, the court is available.
16th September, then say for copy to be given to your attorney. You're on warning, you want for 8:30 district court number 3. If you don't come to court, your warrant of severance against you. 16th September.
16 September.
Your Worship, with your permission, may I be excused?
Excuse, enjoy your day.
Keep
Thank
well,
you.
enjoy your day.
Thank you. You too.
could please the session minutes for provision of the accused. You have one trial, Your Worship.
No, 2. You've got Mr. Manuleka's trial and Mr. Kumalo's party.
Oh, I forgot about the party. Could please the session.
There was a warrant authorized for the complainant in his case. Is she here?
Let me check, Your Worship. May I have the charge sheet?
Let's check.
Siyabonga Shezi, Siyabonga. Members, please assist. Shezi, Siyabonga. Phindile Nkosi.
Because she's here, let's turn it down.
She is here. She could please assist.
Mr. Shaziston, let's turn your matter down. We'll proceed with it after the bail application, okay? The complainant is here. Is it her?
Finalizing consequence. Yeah, this is a lady.
Oh, okay. She looks
I
different.
should be one, Worship, not two.
Mr. Kumalo will assist you.
The complainant, Worship.
Ma'am, we'll call you after this matter. We'll proceed with. We need to finish your evidence.
May I be provisional excuse, Your Worship?
You're
Maybe
excused,
excuse
please.
me. Provisional.
You're excused. Thank you. Where's Mr. Vilagaz? Miss Malwa?
Worship.
Where's Mr. Vilagaz?
He was.
He went outside to issue.
He went.
Maybe he went to point number 1.
Is Ayo calling him?
Maybe it's just a.
Yes, you're excused. Thank you, Miss Malwa.
Morning, Worship.
Oh, Mr. Vilagaz.
I was just outside Worship.
I thought you don't have matters in this one.
I do have matters, Worship. But I was hoping that we start with this bail application first and see how far it goes before I go to my own court.
Let's see. We're almost done anyway. Isn't it? When you're ready, then. Where's the defense?
I'm told they're downstairs consulting.
You must come up. I'm calling the maid.
Can I borrow the shot sheet?
Sure. I haven't put it together. I give you my appearance again. Here. Do you have an appearance sheet there? Ms. Villar, do you have an appearance sheet?
I do not have your.
Or must I give you?
Yes, please.
Yes, here we go. So what's happening now? Then they will complain that they say this matter is delayed when they're delaying a bit. Mr. Malamela, call them. Oh, I adjourn, one of the two.
Can I?
You want an adjournment? Should I adjourn?
No, they put in the. I hear that only now are the accused person coming from Boxburg.
So should
The police van is driving in just now.
So they need to be.
Or they've just arrived. Put it like that.
So must adjourn.
I don't know whether they have to be processed first before they come up.
It's a long story, yes.
Are they coming? So we're on record, if you may proceed.
Yes,
Calling case number TC2/2022/24 in the matter between the state versus accused number 1 Paseka Franz Motsoeneng, accused number 2 Vincent Camilot Baloy, accused number 3 Revival Motsoeneng, seated at the Palm Ridge Magistrates Court in the District of Kulini Central. Today's date is the 19th of August 2024. Appearances are the same as before. Matter before court for a little party, Your Worship. Form appeal application party.
Yes, on the Friday, the 16th of August, we concluded the matter where the respondent closed your case, correct?
In this social.
So Mr. Ponyana needs to interpret the affidavit of the investigating officers to the applicants before court. Mr. Ponyana, when you're ready, gentlemen, please sit down.
tla tsamaya ka tsela e latelang wa hlalosa rena ke ngwefe Masile Dikatene o na le dingwaga tse 22 a sebetsa jaaka lepolesa ko station sa Kokurweni dintlha tsotlhe tsa dipotseng wa di tseba le hape o dumelana le tsona wa hlalosa gore mo molatong ene ya Xhosa le yona nna ka tlhosiwa ba batlhano empa o tshwere ba bararo fela ba babedi ba setseng santsane ba balebe ya pe wa dumela gore kopo ena ya yona ya bedi ke ya 75 jaaka na ka hlalosa gore e ba mosebetsi ya yona jaaka na tlhosiwa fana ka bopaki le mabaka gore hobane go tla le tshwanetse le dumele kopo ya yona ya o lekola ka pedi wa hlalosa gore le melato ene ya Xhosa yona ke ya motsotswana ba santsane ba tlotsa dipatlisiso o fumana melato e mengwe e batla le Xhosa ka yona wa hlalosa gore jaaka le Xhosuwa le bahlano le le entse melato ena ka maikemisetso e tshwanang e nngwe ya melato e tshwaretseng yona e tla bana ya ka tsela e latelang ya ho qala ke kidnapper kgotsa go etela ka Sesotho ba di Xhosa melato e mebedi hobane le lela go etela bana ba babedi o tshosetsa ba le Xhosa hararo o kena tshepeng o sena tumelo kgotsa buka e le ka e fumanang monga thepa e leng trespassing ka sekgowa o tshwara sethunya se se tlasa molao o sebetsa jaaka modisi kgotsa security o sena ditokomane tse di dumelang sethunya setšhabeng le hape o hlasela ba di Xhosa habedi to supa motho ka selo se se shebegang jaaka sethunya le hape o senya kgotsa o thuba thepa ya motho ke yona melato e di shebaneng le yona eo ba tswela pele ba hlalosa ka mokgosiwa wa ntlha e leng Paseka kgotsa Pastor Mboro yena wa hlalosa gore nako e a ne ba mo tshwara o ile a re yena o nyetse empa a so ka mo bona a na le mosadi o ile a hlalosa gore Mboro o tsetswe Katlehong o ile a tshwarwa ka di 6 tsa August 2024 ka 4 PM motshehare go Ramokulupi le hape ba fumane a tlhatlheletswe molato o mongwe wa ho thuba thepa le hape price ya dilo tsa dithubile e fitlhela ho 11,000 le hape a shebisisa menwana kgotsa profile ya moqosuwa wa ntlhane e leng Paseka wa hlalosa gore ke kgale ntse fana ka di-address tse fapaneng tse sa tshwaneng a lekgotla le batla address ya hae le hape wa hlalosa gore wena jaaka moqosuwa wa ntlha o ile a tshwarwa hao moo le hape melato eo ye ya fella moyeng a sa tsebe gore e le ya fella ka melato eo empa o tla etsa dipatlisiso o fumana gore melato e ba Xhosa yona e re bo ile ya fella a ba tswela pele ko moqosuwang wa bobedi a ba hlalosa gore yena o sebetsa jaaka security o na le jara 43 nako yena ba ne ba mo tshwara o itse o sebetsa jaaka security empa a na ditokomane tse tlasa molao tse mo dumelang gore a sebetse jaaka security la tshwara ka 6 tsa August 2024 ka 5 ya hoseng ba mo fumane police station le yena nako ene ba mo tshwara bila hlalosa gore yena ka se bue sepe melato yohle ya Xhosa yona o tla iseka pela le khotla la molao le apela hana araba le ba mo botsa gore anana le moqosuwa wa ntlha nako ene ba tshwarwa le hape anane ba tshwere sethunya le apela hlalosa polisa gore ga ba gona o sheba menwana ya moqosuwa bobedi o ba le ba sena ID kgotsa ID number ya moqosuwa bobedi a ba hlalosa mabaping a se se boneng ke bapala o la sebedisa mopaki wa ntlha o la hlalosa gore yena ka letsatsi la ketsahalo o la bona ngwana monyenyane wa ngwanyana a ba le a tswa sekolong a re go na le motho o tshwereng sethunya sekolong le hape bana ba sekolo ne ba baleya ba phatlhalla le hape ba ile ba romela mongwe wa setšhaba a lo sheba gore go tsagala eng mo sekolong a fumana o tletse batswadi ba bana ko hekeng ya sekolo le bana ntse ba baleya ba phatheletsana ba sebedisa mopaki wa bobedi o mongwe wa hlalosa gore o ile a bona moqosuwa wa ntlha e leng Paseka Mboro a kena sekolo a tshwere sethunya le hape o na batla ho nka ngwana a sena tumello kgotsa tokelo e tswang ho motswadi wa ngwana kgotsa motho ya tlhokomelang bana le hape a sena tokelo ya ho kena sekolong seo ba sebedisa mopaki o mongwe wa bobedi o sebetsang ko sekolong wa hlalosa gore ila hlalosa gore yena o sebetsa mo le hape wa netefatsa gore bana ba dula le mme le ntate wa bona empa mme sa hlokofetse le hape wa hlalosa gore mme le ntate wa bana ba nyala ba hlalosa gore fa mme a fetsa go tlhokofala wa mme bana ba ile ba simolola ba lo dula le kgolo wa bona ya tsamayang mme wa bona ba hlalosa o mo se a se boneng ka di-1 tsa August wa hlalosa gore ile bona motlosi wa boraro e leng revival yena a kena a tlo ka bana sekolong a sena tokello ya motho o tlhokomelang bana wa nka bana le hape taba ena ketsahalo ena ba ile ba isa maponeseng ba re molato le hape maponesa a tsamaya a lo sheba bana empa ka bomadimabe a ba bo fumana le revival mo a dulang teng le hape wa hlalosa ka letsatsi le latelang bana ne ba sa sekolong le hape ha ne ba tswa maponesa ba lo sheba hape ba fumana motlosi wa ntlha e leng Paseka a na le bodyguard ke mo he yena Paseka a ya ka aja hae a tswa ka diphanga tse pedi ke mo he ka bomadimabe maponesa a mothiba ba sebedisa mopaki o mong hape e la hlalosa gore yena se a se bone gore o bone bana ko sekolong le hape ba hlalosa gore yena o joditse gore bana ba tlisitswe ke motlosi wa boraro ko sekolong le hape wa hlalosa gore pastor o ile a kena ka phanga le hape a tshosetsa batho ba ne ba le ko sekolong mopaki o mong yena wa hlalosa gore o bone motho ya motho a tshwere sethunya se seholo le hape ke mo ene ka letsatsi le la ketsahalo a se a se bone o la bona motlosi wa bona ha o kgotsa revival a re o batla bana ba hae ke mo he le hape motlosi wa ntlha o ile a sebedisa phanga ene a itshwere go heke ya sekolo gore a kene ka matlo ka mo he engwe ya melato e le shebaneng yona ke a thuba kgotsa o senya thepa ba ne le la bula heke ya sekolo ka phanga le hape ba hlalosa gore a le fetsa go ka bana le la thunya moyeng go netefatsa gore batho ba phatlhagana le gore ba le tsela ya go tswa la tswela pele hape a sebedisa mopaki e leng kgono ya bana wa hlalosa gore yena mme le ntate wa bana re ba le ha ba nyala le hape ba netefatsa gore bana ba nkiwe a sa tsebe kgotsa a sa fana ka tokello ya gore bana ba nkiwe le hape wa hlalosa gore yena ka letsatsi le yana ya la ketsahalo eo ana ile a lo nka bana morao ho sekolo setswe empa o makala sa fumana motlosi wa boraro revival a kene a sekolo a tsa le ka bula heke ka matla ka dintlha tseo wa hlalosa gore yena le bonisa le tshwereng molato ona gore bana ba ba nkiwe ka di-1 tsa August ho fitlhela ka jeno a ba tsebe gore bana ba kae le hape bana ke batho ba nang meriana ba bane ba fumaneng ba tla kula mmeleng le hape a ba sa fumaneng ba tla sala morao mabapi a dithuto le hape wa hlalosa gore jaaka le batlosiwa le na le dithunya le na le dikulo tse seng tlasa molao tsena tse di bontsha le batho ba sa tshepahaleng le hape le ka ba batho ba kotsi mo setšhabeng le hape ba hlalosa gore molato ena le etse le bahlano le na le maikemisetso a tshwanang le hape wa hlalosa gore motlosi wa ntlha o ile a thunya sethunya phatlalatsa gore batho ba tloetsileng o tla kgone go ba lia mo ketsahalo eo ile ya etsela teng ona batlosi ba ntse ba bapaki kaofela re tla ba tshosetsa re tla ba kenya ka kelello fale ka lekolla le hape la tseba gore melato e le tshwaretseng lona le ka tlosiwa kgotsa la fumana la molato le ka tlhatlhelwa nako e ngata se se hlalosa gore fane go tla le lekola ka pele le ka baleya le ka dintlha tseo le hape wa hlalosa gore bangwe ba setšhaba ba tletse mosito le hape ba tshepisitse go le bolaya ke ka go ba ile ba tupisa kgotsa ba besa kereke ya lona ka dintlha tseo tsotlhe o kopana go tlalisa dumela kopo ya lona ya go lekola ka pele.
Thank you. Yes, Mr. Vidakasi, that's the evidence for the respondent, correct?
Bishop, sorry?
That's the evidence for the respondent.
In the social.
Ready for arguments, Mr. Lamini?
Your Worship, I have just requested my colleague to provide me with the statement that has been read, and not to disturb the court, I could not, because he was reading fast, I could not follow properly. And in my advised to the third respondent, I thought that the death accused number 3 of the third applicant, that despite that the issues that were the statement read to the court, I had not seen it before, and up to now I do not have a copy, but I felt that he can draft something to reply to some of these issues. That, Your Worship, I will ask the matter to stand down for my brother here to get me a copy, and at the same time my attorney to commission the affidavit of the third applicant, just replying on some of these issues. I'm aware that it's a hearsay, but we feel that we need to give court a clear picture of what is the issue before court, to enable the court to have a better picture and come to an informed decision.
Are you then also saying that you intend then to reopen your case then?
Not exactly, Your Worship. The issue is responding to what the state is putting before court. Not reopening, it's just that position to say this is the position. If the court is not acceptable to that position, we prepare to continue with the argument.
Mr. Vilagazi, your response to that?
As it is the court, Your Worship, the state does concede that a copy of the investigating officer's affidavit was not provided to the defense, Your Worship. I became aware that I'll be doing this matter a few minutes before walking in Friday, Your Worship, to proceed with the matter. I wasn't aware that there was just one copy in the docket, Your Worship. However, there's still time, Your Worship, for the state to provide the defense with copies. And as regards otherwise an application by my colleague, Your Worship, to respond to the state's submissions, Your Worship, it's a procedure I do not come across on a daily, Your Worship. We leave it in the court's hands, Your Worship. However, what the court should take into account, Your Worship, is for this matter to reach its finality, Your Worship. I feel that to go back and forth, Your Worship, in responding and replying to statements or submissions made by the defense, Your Worship, will not only delay the matter, Your Worship, however, will cause the state some prejudice, Your Worship. However, we leave it in the court's hands, Your Worship, to make a finding on such an application, if at all it is an application, Your Worship.
Okay, so maybe you're saying that you want to, you would request that you want matter to stand down, you draft the affidavit quickly and then you present it. So what
Your Worship, let me withdraw that.
Because I can grant you that indulgence.
Yes.
I mean, it's a bail application. Anything goes in a bail application. So
let me withdraw that, Your Worship.
Yes?
Let me withdraw my application now, and we continue with the.
Are you withdrawing it?
With the argument.
Are you sure?
I'm happy with that, as long as my colleague will provide me with a copy of the statement.
Okay. You make it available, Mr.
No,
Vilagazi?
in this social. In a few minutes' time, I can make all copies available.
Do you want it now, Advocate?
Yes, I'll use it in my
Okay,
argument.
then it's safe to say then we'll take an adjournment. It's 09:58. I'll come back at what? 10:15.
In this social.
Because he needs to go through the affidavit. Is that fine? All right, then. Matter stands down then for copies we made to the defense counsel. Okay, I'm going to take an adjournment. Mr. Ponyani? Court adjourns now.
All right.
Everything is enough space. Yes.
So I'm trying to make this further away from you. Thank you so much.
Where are the accused? Did you have your copy?
I received a copy.
Yes, Mr. Vilakazi.
Worship,
On record.
we're back on record, Your Worship. Your Worship, I believe my colleague has went through the affidavit, Your Worship, and is satisfied. You can proceed.
Yes. Mr. Dlamini, your arguments in closing. Yes, you may proceed.
Thank you, Your Worship. This is an application for bail. The applicants are facing Schedule 5 charges. And I want to emphasize Schedule 5, not 6. In terms of the CPA Act. The applicant have been given reasonable opportunity to adduce evidence which they believe will satisfy the Honorable Court that the interests of justice permit for their release by bail. That's all what is required from the applicants to satisfy this court that it is in the interest of justice for their release. I must point out, Your Worship, that the applicant are charged of 2 times kidnapping involving 2 kids, intimidation, trespassing, contravention of Section 120 in bracket 3 in bracket B of the Firearm Control Act. Failure to produce license for the firearm when so requested. Contravention of Section 20 in bracket 1 in bracket A of PSIRA. Discharge of firearm in build-up area, 2 times assault, pointing of a firearm, possession of unlicensed firearm, in bracket a rifle, possession of dangerous weapon, 2 pangas, in bracket, malicious damage to property, vehicle belonging to maternal family witness. Your Worship, this is an interesting case. As you can see, the media in this court. Senior police officers are in this court. You have various Department of Education are observing this matter. It is a case of public interest. I just want to draw your attention, Your Worship, that this must not make the court lose sight of the interplay between private law and criminal law. And supporting what I've just said, Your Worship, I will refer you to the matter of Motsoeneng versus the state. Let me try and give you a proper citation, Your Worship. Motsoeneng versus state in bracket R03 in stroke 19 and in bracket 2020 ZA MP MHC 32/23 July 2020 at paragraph 1. Brookman AJ, as he was known at that time, stated the following: in this review, Tone is reminded never to lose sight of interplay between private and criminal law. The law is dynamic, and students have over the years, just like courts, sometimes struggle to keep that in mind. I'm trying to argue, Your Worship, to say there is a similarity in this matter. There is element of private law, there is element of criminal law, so it must be balanced. I've already said, Your Worship, that it is a typical case of interplay between private law and criminal law. For the following acts are applicable. And I want to bring Your Worship to say that there are other laws that are applicable in this case. Section 28 of the Constitution of the Republic of South Africa. It deals with the right of children. Section 20 and 21 read with Section 7 to 9 of Children Act 38 of 2005. Section 3 of the South African School Act 84 of 1996. These acts have a bearing in this matter. Your Worship, you'll forgive me, I will slow down to allow the interpreter to write.
No problem.
I realize it looked like I'm increasing speed. Your Worship, to understand the interplay of these laws, I would like to start to talk about third applicant or third accused. The state is opposed to granting of bail for the third applicant or accused. The refusal is based on the statement made by the investigating officer. I've already highlighted the charges, Your Worship. But one important charge, Your Worship, that I want to dwell a little bit on it is the kidnapping, 2 times kidnapping. Your Worship, it's common cause that that applicant or accused number 3 is the father, or let me put it correctly, the biological father of the alleged kidnapped children. And in terms of the law, he has a right a legal right to look after his children. That's what the law says. It's not me, Your Worship. It is the law. the law gives unmarried fathers the right to their children. The law makes it very simple, Your Worship. It says if the child is born when the mother and the father are staying together as man and wife, the father has a right to that child. That right doesn't end there, Your Worship. It goes with other responsibilities. The father is responsible for maintenance of those children, upbringing of those children, health of those children, schooling of those children. That's what the father is about. The law of this country promotes that. That's why we have this Children Act. That's why the Act makes it very clear who is the parent. Your Worship, I've just demonstrated a little bit that the charge of kidnapping has no basis. Keeping the said applicant in prison without a basis goes against first the public interest, secondly the rule of law, and lastly the interest of justice. People are using the law to do wrong things. Your Worship, the state has not put any documentary evidentiary proof that either the grandmother or any other person has been granted by family court or any other court that has jurisdiction, authority to take over the children from their father. One of the rights children have from their parents is protection. This right comes from generation to generation. Fathers protecting their children and their grandchildren. The rights of children, the best interest of children is with their parents and their family at large. Paternal family at large to the best. Your Worship, the applicants, let me put all of them, the state has failed to contradict their submission relating to the requirement of section 60 in bracket 4 in bracket A of the Criminal Procedure Act. The state has not alleged that there is likelihood that the third or the second or the first applicant, if released on bail, will endanger the safety of public or any particular person or will commit a Schedule 1 offense. In that way, I submit, Your Worship, that the submission of third, second, and first applicant has not been contested. In fact, to the best, they have been confirmed by this state. Your Worship, the public is abused. Which public will turn against a person who has the rightful authority to look after his children? The state has not produced any documentary proof that the relevant children court or any court that has jurisdiction has removed the children from their father and granted to their grandmother or any other person. The state has not produced that evidence. And thus it cannot contradict this particular section 60, 4 in bracket, A in bracket. So that is not contested, Your Worship. I submit. I now go to section 60 in bracket 4 and bracket B. The state has not contested the submissions of the third, second, and first applicant, but it was playing into the public gallery, raising issues that are not relevant to this bail application. I will address it later. The state has not alleged that if the third applicant is released on bail, will attempt to evade his trial. Let me put it better in saying the state has not alleged that the third, second, and the first applicant will attempt to evade their trial. In reality, that has not been contested. That's the reality of the situation. In terms of section 60, four in bracket, D in bracket of the CPA, the state has not been able to contradict the submission of the first, third, second, first applicant. This relates to if the applicants are released on bail, will undermine or jeopardize the objectives of a proper functioning of the criminal system, including the bail system in terms of Section 60, 4 in bracket, D in bracket of the CPA. Again, Your Worship, the submission made by the applicant has not been contested. So this particular section has been complied with. I now address you, Your Worship, in terms of Section 4 in bracket of the CPA. The state attempted to allege boldly that there is likelihood that the release of the third, second, and first applicant will disturb the public order or undermine the public peace or security. The allegation, Your Worship, is not substantiated. In fact, the state fails to contest their submission in terms of Section 4 in bracket, Section 16 bracket 4 in bracket E of CPA. The bold allegation by the state that the first and second applicant are a danger to community. It's not substantiated. Or the community being danger to the first applicant, it has no merit, Your Worship. It is something that the police is trying to put this court in a situation where it will be on doubt. Your Worship, in the last 2 weeks there have been a church in Katlehong, and the people of Katlehong have been supporting. And the people of Katlehong are not against the law. They know, and the police know, who is the father of the children. They know very well. They wrote in their own statement that the accused number 3 or the applicant 3 is the biological father of the 4 children. It's not me, Your Worship, is the police who said of the 4 children, and it is confirmed, yes, he has got 4 children. It is the police who have confirmed, Your Worship, that the third applicant or third accused was staying with the mother of the children in a hired room, confirming, Your Worship, what the law says. If a child is born between the man and the woman, not married, staying together, taking themselves as man and wife, the father has the responsibilities for those children. He's got the right. Your Worship, you can't charge the man for kidnapping his own children when he had the right given by law, except if you produce evidence that the law has removed that right. Only the law. Only the law can remove that right, that parental right of the third applicant. Your Worship, I have displayed to you that the allegation that the community is in danger, it has no substance. It has no basis. In fact, Your Worship, the church is just behind the police station. It could take to the west less than 3 minutes to reach the church. But because they are playing into public gallery, they want everybody to see the best accused to be so bad in community, and they come up with all these allegations. In fact, it looked like it has political connotation, Your Worship. Because how could a man charged for protecting his own children, looking after his children, looking after the education of his children? Your Worship, I have not even mentioned the issue of the fact that the father took the children to school, and he has a right to take them back home. So if he fought for his children, being denied his children using the SAPS. That's the reality of the situation, and not all what is going to be displayed that the pastor just went to school. Your Worship, if you get a call that your daughter is being attacked, I can assure you this hearing will be postponed for you to address that, because it comes inside you. The motherly and fatherly comes up, and if the best accused is being told that his child is being attacked for his grandchildren, can he stay? That will be addressed at the trial, Your Worship. I don't want to go in there. And I've said, when they raise these issues of issues that are not supposed to be in this court, and I did stand up and said that issue is for trial, and they continued with it. Your Worship, the public needs to know the truth, and the truth shall set them free. And in this situation, I believe that Your Worship, it has been brought to my attention that on the 5th of September, the issue of children will be dealt by a court that has jurisdiction. And I don't understand why should the father be charged for kidnapping. That's the worst situation. kidnapping is a serious offense. Purely because the police are trained enough, they know the law, they know the rights of parents, they know what is supposed to come to them before they act. And they acted without all that information. And that's the situation, Your Worship. Let me, Your Worship, just show you common cause issues. Both parties, the state and defense, agree that the third applicant is the biological father of the children alleged kidnapped. The first applicant is the biological grandfather of the two children alleged kidnapped. And it's common cause, Your Worship, that the third applicant is the son of the first applicant. It is common cause, Your Worship, that the third applicant and the mother of the children were staying together as man and wife, having equal responsibilities. You know, this country, the constitution of this country brought great things, more specifically for women. Before this constitution, women were down there, and this constitution gave them the 50-50 position. And that is reflected in the Children's Act. More importantly, the children, whether born in marriage or out of wedlock, have equal rights. This didn't happen prior to the Constitution. These rights, Your Worship, cannot be taken by anybody except the court that has jurisdiction to do so. Not even police can take it. They cannot abuse the law because they are policemen and just go and arrest a father of a child on a serious allegation of kidnapping. That's an international problem of kidnapping children. It's an international problem. So you cannot just plug it anywhere where you think it will suit. It is common cause, Your Worship, that the father took the children to school as required by law, that every child has the right to education, and the child below the age of 17, the parents must make sure that the child go to school and account for that child. The father is here, the children can't go to school because they lack that protection. Their father is their protection. It's common cause that these children are not well, Your Worship. The state, in its own affidavit, it alleges that they've got chronic, and that's true, Your Worship. That's the position of the children. They need their father. They need their grandfather. That's the position, Your Worship. Now I have alluded, Your Worship, that there are law applicable parental responsibility and right of unmarried fathers. Section 21. Section 20 deals with married fathers. It gives them their right. Section 21, 1 in bracket, of the Children Act 88 of 2005 gives full parental responsibilities and right in respect of the third applicant or third accused. And thus a charge of kidnapping is scandalous, vexatious, and irrelevant. The Act, Your Worship, provide a mechanism when the two parents have dispute about the child. Thus we submit, Your Worship, the dispute can only be between the mother and the father when they are all authorized guardian or parents in that fashion. If he has authority from court that he is looking after the interest of that child. The court must first grant a person custody of the children before the person can claim to have authority on the child or children. You can only do that when you have been granted custody by the court with jurisdiction to do so. Not policemen. The policemen do not have that power to grant anybody authority to take over the child belonging to his father or mother. So the state has failed to come up with a clear position showing that children were lawfully removed from their father. I've not seen anything. There is no allegation, not even a hearsay, Your Worship. At least there is a hearsay on other issues, but there is no hearsay to say the grandmother, maternal grandmother, has authority to remove these children from their father. The state confirmed, Your Worship, that the mother and the father, the third applicant, were staying together. That's the state, not me, Your Worship. It is the state confirming that. And they fail to produce evidence or allege that the mother will produce authority on trial showing that he was granted custody of the children. The removal of children from their parents can only, and I repeat, can only be done by the intervention of social workers, family advocate, social services professionals, or other suitable qualified person. And lastly, court with jurisdiction to deal with such matters. Now, those other people will have put recommendation to the court to deal with that situation, to remove for good reason, not just because the mother of the children has passed on, so anybody can just have access to those children. Doesn't work like that. Whether customary or in a civil society, it's worse in our constitutional democracy, because the law is clear about children. I've already alluded, Your Worship, that in terms of Section 3 of the South African School Act 84 of 1996, the third applicant is required by law that he must cause his children to attend school. That he cannot do locked up. This means taking them to school and picking them from school. In this way, my Lord, my worship, the charge of trespassing is against scandalous, vexatious, and irrelevant, because he is required by law to take the children to school and to pick them up at school. Your Worship, I've already alluded that any parent, no matter the child is smoking nyaupe or do anything, drugs, but if it's your child and you hear that it's being attacked, you will jump. You will even forget that the child is under the influence of nyaupe, because it's a parent. It is, you're born with it. It is there. I once saw one of the TV interviewing an old man sitting there with his child being beaten because he's smoking nyaupe. And when he asks, how do you feel? He says, I don't agree with what my child is doing. But it's my child. There is no way I can denounce him to be not my child. And that's the issues, Your Worship. You'll realize that as soon as accused number one is told that his child is being attacked, he has to go there. Your Worship, it is very interesting, and perhaps this will come up in trial, where the education will explain how did they come to the conclusion to deny a father his child. And in fact, they're supposed to be protecting those children and know who's the parent of the child, who's the father and the mother of that child. In my experience, Your Worship, whenever I go for my grandchild at school, the school teachers and principal will ask me, where is the father or mother of the child. And this is done effectively every time I go there. In this case, I do not understand, Your Worship. Perhaps the state will give us a clue on that. How do they prevent the father to take his own child? On what basis did they do that? Perhaps, Your Worship, some people have connection at the school that says deny the biological father of the child from taking his child home. Your Worship, the whole issue of this centers around the two children. Whatever we're talking about centers around the two children. And the question of what the state is alleging, danger to the community. Which community is in danger? Because if that school doesn't want those children, the father has the responsibility to look for another school to take his children to that school. So what danger are the applicant posing, specifically the third and the first applicant posing to the community? That position has no basis, Your Worship. It is just playing politics in court. Or they act on some instruction from above that makes sure that the first accused is not getting paid. Not because the law says so, not because there are tangible reasons that can be given that will make the first, second, and third applicant not to be granted pay. My Lord, let me refer, Your Worship, let me refer you to the case of State versus Diale and another. At paragraph 14, Kubushe J states the following: a court cannot find that the refusal of bail is in the interest of justice merely because there is a risk of possibility that one or more of the consequences mentioned in section 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made unless it can be found that one or more of the consequences will probably occur. Detention of the accused is not the interest of justice. And the accused should be released. This is a typical case of where the accused are kept in prison not in the interest of justice. Your Worship, let me refer to another case. In the matter of Sinwedi, if I pronounce it properly, it's Senwedi versus State. The highest court of the land, the Constitutional Court, at paragraph 27, stated the following: with regard to a person's right to freedom, our courts must defend and uphold the Constitution and the right entrenched in it. One of the most important rights from a historical perspective is unquestionable deprivation of individual individual's liability. Liberty, not liability. Liberty. This court said in Ferreira that C, in bracket C, conceptual individual freedom is a core right in the panoply of human rights. And I'm aware that the human rights people are here. They may understand that these rights are protected. The apartheid regime repulsively and capriciously deprived people of their freedom under illegitimate legislation. I'm a victim of that, Your Worship. That paid no respect to the right to freedom and security of the person. We are therefore constrained to jealously guard the liberty of person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. Your Worship, we need to protect this right. It's a right that only when the state show beyond doubt that the person has committed something that may disrupt the administration of justice. Your Worship, I refer you to the matter of DJVV D.J.V.B and others vices the state. My favorite Judge M.F. Lekhodi states the following: bail conditions have always served to ensure that whatever fear the state might have in the release of the accused person is taken care of. It is necessary consideration as also envisaged in Section 60 in bracket 6, which provide that in considering whether the ground in subsection 4B bracket has been established, the court may, where applicable, take into account binding effect and enforceability of bail condition which may be imposed and easy, which such condition could be breached. Your Worship, I have dealt with the situation more importantly of the third applicant. Without the third applicant in picture, the rest wouldn't be before you. Before people take me wrong, Your Worship, the man and the women in blue uniform, they do a good job. But sometimes you have those that tend to focus on other issues. And therefore, we respect the men and the women in blue uniform. They do a good job. They make sure that we are safe. And when I'm dealing with this issue, it should not be as if I'm criticizing the police. That's not the case. Your Worship, the prosecution is not a rubber stamp for police. They are not a rubber stamp. When the police want somebody to remain in prison, they should not expect prosecution to just rubber stamp what they want. No, the court is not their rubber stamp. The prosecution and the court are independent of anybody, and they administer fair, equitable justice. There are few issues that I want to address Your Worship, about the second applicant. The police have confirmed that they have gone to the address he gave them as his home, and they have confirmed that he is not staying there in that address. He frequently visited. It's not new with the accused for a person who works somewhere else. It has been done since the white men came into this country. We have been staying in the compound, hostels, and go home once a year. So it cannot be an issue that the accused, the second applicant, goes home once, or it does not stay there frequently. It's not an issue, Your Worship. It is there. It is normal to African people. It is daily. It won't stop now. No democracy has failed to stop it. You have people moving from the rural areas all over to stay in the squatter camps. It's not their own making. It is the situation they are faced with. The accused, or the second applicant, he has demonstrated in his affidavit that he stays at the employer's property. There is nothing unlawful about that. In fact, the state, when I say the state, Your Worship, please forgive me, I do not refer specifically to the prosecutor. I'm referring to the police. The state has confirmed in their hearsay evidence that the second applicant was arrested at the police station. He was not on the run, Your Worship. He was not any other place. He was arrested at the police station. So what danger, if he can't go take himself to the police station, what right do they have to even try to allege that he is a security risk and a danger to the community? That won't stand, Your Worship. Then they come up with the allegation that his ID, they didn't have the ID document. It's the work of the police to go and get the ID document where he stays. And they have not done that. So they cannot put a blame on the second applicant. In fact, the ID number is mentioned in his affidavit. So that in itself, it has been taken care of. The state wants to focus more on flight risk. All the applicants have stated that they do not have families outside the Republic of South Africa. They have already stated again to say that they have no intention to evade coming to court. And that has not been contested, Your Worship. Has not been contradicted. There is no single clue that shows that they are a risk. I've already argued, Your Worship, that in terms of section 60 in bracket 4 from A to E, that the state has not contested all those issues. And the second applicant, Your Worship, there is nothing in law that makes him to be denied bail. Nothing, Your Worship. I now want to dwell on the first applicant, the target that the police have. In actual fact, 2 and 3 suffer because of accused or first applicant. Perhaps that's why we see changing of prosecutors as a sign that perhaps the other prosecutor does not agree with what the police are asking him to do.
Your Worship,
Yes.
my apologies, Your Worship, but such innuendos are unacceptable, Your Worship. How
Yes.
does he know all of that?
Katlehong, I feel like you're attacking.
I mean, that's unacceptable.
Your Worship, I will withdraw that.
Yes, please.
Right. The first applicant, a known pastor, more popular throughout the country, born and bred up in Katlehong. There's no question about that. It's common cause and common knowledge. I want to address first the issue of 9 charges withdrawn. Perhaps, Your Worship, it's my lack of understanding or interpretation of the word withdrawn. If my understanding, the state only withdraw a case when it has not gathered sufficient evidence take the person to court, perhaps successfully. That's the issue. My understanding that I do not think that until that matter is brought back to court, the person must tell the court that I've got 9 or 7 or 1 withdrawn case. That's not what the law requires. The law requires previous convictions, outstanding charges, and not withdrawn cases. They are neither there they do not assist the court to come to the right conclusion. The investigating officer tell this court that some of those charges are being investigated and may be reinstated. But it doesn't say when were those charges leveled against the first applicant. When were they withdrawn? It could be 30 years, 40 years, 50 years, or a year, or 6 months, or 2 days ago. We don't know. The court cannot work on speculation. Does those charges contribute towards granting or refusal of bail? Your Worship, I submit that they are not relevant. It's just an effort to try and dent the image of the first applicant. Your Worship, I am of a belief that the court should consider each case on its own merits. There should be no impression created that the prosecutor is just a rubber stamp of the police as regarding whether granting of bail or not, and as well as the amount of bail to be paid by the applicant. In conclusion, Your Worship, I have demonstrated to Your Worship that there is nothing in law placed before this honorable court that will make this court not to grant the bail. I have demonstrated to you, to the court, that the continuous detention of the accused or the applicant is against the interest of justice. Your Worship, can I approach?
Yes, you may.
Thank you, Your Worship. Oh, by the way, I said in conclusion.
Yes.
Let me conclude, not to start afresh. Your Worship, this is the case of the applicant, and if there is any other issues that Your Worship wants me to address, I'll be able to do so, or to clarify. I'll be able to do so, and I know as an old man, I take my own time, and even thinking comes later. I think, Your Worship, I will stop here and allow my... Thank you.
Thank you. Yes, Mr. Vilagazi?
As the court.
Sorry, before that, Mr. Poyen, you want to interpret this one first or combined? Let's give Mr. Poyen to translate for the applicants.
Ke sona se ne a ska lo sa phapang ba batho ya disele e go sena ke se ke ka ba disele 6 le hape wa hlalosa mabating a melatele le shebana e le khosana la la kota la molao e le go kidnap ba ba di go thusetsa tshwara sethunya o sena ditokomane kgotsa license thunya sethunya pela setšhaba kgotsa lefelo le tetseng batho supa motho ka sethunya tshwara dithala kgotsa selo se botsi tshwanetse ba motho le hape ke tsona e dintlha tse a ntlhalosa mabapi le molato e le shebane le ona a ba hlalosa gore molato ona o shebuwe ke naha ka bophara le hape na le department tse fapaneng tse tlileng e leng ba sekolo ba ke ba tlhansi se wa hlalosa gore o kopa le kgotlale ele tlhoko mabapi le melawana e tla sebediswang melawana ya private le melawana ya criminal ba le kgotla e shebisitse hantle ka melao ena e tla sebetswa kgotsa e tla sekwa ka melawana e mengata e tla tshwanela go latela a ba kenella ya gore mabapi a moqosi wa boraro wa hlalosa gore mosepisi o kgatlanong le pedi mabapi a se kwetseng ke leponisa le etsang dipatlisiso kgotsa se a se kwetseng mo lokalong la boikanyo ba ba hlalosa gore molato o tlosang ona kgotsa molato o motlosiwa wa boraro a o tlosang ona wa okipepa a o hlalohanye hobane wa tsebahala pela lekgotla gore yena motlosiwa wa boraro ke yena ntate wa bana ba ba kilediweng se hlalosa gore ya ka molao ke yena a nang le tokelo ya ho hlokomela bana a ba ise sekolong a ba latela sekolong a sekolo setswa le hape ile wa bua kgotsa wa hlalosa mona lekgotleng gore bana ne ba dula mmoho le mmabona le ntata bona la ntse ba sa nyala se se hlalosa gore ntate le yena o na le tokelo ya ho hlokomela bana tokelo eo e tsamaya le maikarabelo a ho netefatsa gore wa ba hodisa bana ba isa sekolong le hape wa ba fepa le ke ka hore he a sa hlalohanye ba neng motlhosi wa boraro a tloswa molato wa ho kidnapa bana ba batsalang ba hae ba madi le hape wa hlalosa gore ga gona bopaki bo bo tlisitsweng go bontsha gore go ne gwa ba le lekgotla le le nang mokela ditokelo la gore a dule le bana kgotsa a ba hlokomela ke ka hore yena a sa hlalohanye molato o ba motlosang ona wa ho kidnapa bana a ba hlalosa gore ba mmuso kgotsa mosekisi o hloleile go bontsha ka bopaki le ba botlalo gore go ka etsagala gore batlosiwa fa ba ka lokolwa ba tla baleya kgotsa ba sa hlaela pela go tla fa ba ka lokolwa ka pele le hape wa hlalosa gore ga gona tokomane kgotsa lekwalo le kwetsweng pela lekgotla le le hlalosang gore ntate kgotsa motlosiwa wa boraro a sana ditokelo tsa gore a ka dula le bana kgotsa a hlokomele bana ba hae empa dintlha tsohle tse di buang ke mosekisi ga ona mo di kenang teng mo molakeng ona o sekwang kgotsa o romanyetseng pela lekgotla le hape ba hloleile ba mmuso kgotsa mosekisi o bontsha ka bopaki le ka dintlha gore tlosiwa fa ba ka lokola ka pele ba tla baleya ba sa hlaele pela lekgotla morago ba lokolle ka pele le hape e na le tlhoso e tshosang haholo ya gore batlosiwa fa ba ka lokolwa e tla ba batho ba leng kotsi setšhabeng le gape ga ona bopaki bo bo tlisitsweng ke ba mmuso go bontsha gore batho ga ba dulelwa mo setšhabeng kgotsa bangwe ba setšhaba ba ka nna kotsing fa ba tlosiwa ba ka lokolwa empa ba etsa mohlala a bontsha gore kereke ya Katlehong na le tse pedi se yutsu se se bontsha gore batho ba setšhaba sa Katlehong ba sa tlhoka batlosiwa ba ba gare kaofela le gape le maponisa ba tseba hantle gore motlosiwa wa boraro ke ena ntate wa bana ba ba kilediweng kgotsa ke ena ntate wa batsala le wa hlalosa gore ya ka molawana wa yona naha ena ya rona ya Afrika Borwa wa hlalosa gore fa mme le ntate ba dula mmoho o sa ile hloko gore ba nyetswe se hlalosa gore ntate le mme ba na le maikarabelo kgotsa ditokelo tse lekanang tsa go hlokomela bana se hlalosa gore na ha hlalohanye hobaneng motlhosi wa boraro a tlosa molato wa ho kidnapa bana ba e leng ba hae ba batsalang empa wa hlalosa gore lebaka le letsang gore ba etse dintlha tsena kaofela ke gore ba le shebisise lona mo setšhabeng jaaka batho ba ba re pela mahlo a setšhaba a ba tswela pele gore yena ntate o na le tokelo ya ho tshwara kgotsa ya ho tlhokomela bana a ba ise sekolong a ba latle sekolong le hapa ba etsa leano ka seemo kgotsa bophelo ba moatlhodi gore yena a nang ka etsa jwang fa ka utlwa gore moradi kgotsa mora wa hae o mathata o tla netefatsa gore buisano kgotsa ona wa molato ona wa ema hobane ke yena mosebetsi wa hae jaaka motswadi wa ngwana a na etsa leano go bontsha gore ke seno sa etsa ke motlhosiwa wa boraro kgotsa motlhosiwa wa ntlha moraga gore a utlwe gore mora wa hae wa hlaselwa setšhabeng ke ka moo he yena o ile a tswa a ya go ketsagalong eo a ba tswela pele gore a hlalosa gore motlhosiwa wa ntlha ke ntate wa motlhosiwa wa boraro se hlalosa gore ke yena ntate moholo le a fana hlalosa a kena a re mme le ntate wa bana ba dula mmoho se hlalosa gore ba aroganya maikarabelo a ho dula le bana kgotsa go isa bana ya ba hlalosa gore molaotheo wa naha ena o fetohile se hlalosa gore basadi sa ba na le ditokelo tse di lekanang le tsa banna le hape ga ona motho a nkela motho o mongwe tokelo e ya fiweng yona ke molaotheo gantle le court kgotsa tsamaiso ya toka ke yona fela na le maatla a o nka dikelello tsa motswadi a ba tswela pele a hlalosa mabapi a seemo sa bana se se tlalosa a na hlalosa a dumela a netefatsa gore ka nnete bana ba ja ditlhare kgotsa ba nwa meriana e hlayang bakeng ya sekgowa se se tlalosa gore ba tlhoka tlhokomelo ya ntata bona ya ntatemolo wa bona le hape a hlalosa gore ntse sa utlwisisong gobane a ntse sa dumelane le molato o mongwe wa go qosa ona wa go kidnappa gobane yena moqosi wa boraro ke yena ntate ya tsalang bana ba babedi a ba hlalosa gore motho o tshwanetse a fumane tokelo kgotsa lekwalo le hlayang lekgotla pele ga ka bana a dumele bona se se tlhalosa gore a se maponisa a na le maatla ao netefatsa kgotsa ao ka qetelwa gore bana ba tshwanetse ba dule le mang a ba tshwanela dula le mang empa ke lekgotla fela le nna le maatla ao etsa qeto eo a ba hlalosa a tswela pele mabaping a seemo sa moqosi wa bobedi a ba hlalosa gore maponisa ka nnete a ile a tsamaya netefatsa address mo a dulang teng le hape ba fumana gore moqosi wa bobedi a dule moo addresseng eo ka dinako tsohle hobane o la hlalosa gore yena o dula le motho ya mo sebeletsang le moqosi wa ntlha le hape o tlwaelehile gore batho ba dule mafelong a fapaneng go ya ka seemo sa bophelo ba bona ke le ha nngwe yena a sa bone bothata o seo moqosuwa wa bobedi a dule ko addresseng e nngwe le motho a mo sebeletsang le hape a ba hlalosa gore ka nnete maponisa a mo fumane ko police station se se hlalosa gore yena a na sena maikemisetso ao baleya ke ka hore he o sena bopaki ba gore fa ka lokollwa o tla baleya kgotsa sa hlaela pela lekgotla la molao hobane maponisa a mo fumane ngwana mo ko police station a ba hlalosa a e feleletsa mabapi a baqosi ba bangwe gore a gona bopaki bo tlisitsweng bo bontshang gore baqosi fa ba ka lokollwa ba tla baleya le hape mabapi a dintlha tse hlano tse lekgotla le tshwanetse le dipontshe kgotsa le shebisise pela gale ka dumela kgotsa le ganetse kopo ya tokollo ya pele ya baqosiwa a ona bopaki bo tlisitsweng gore baqosiwa ba ka se latele melao ba ka se thusetse bapaki kgotsa ba ka se pate bopaki bo tla sebediswang go seka ke tsona tse dingwe tsa dintlha tse hlano tse di šaisiswang le mabaping a melato e robong e leng ya qoswa moqosuwa wa ntlha wa hlalosa gore ga ona molao o ileng wa hlalosa gore moqosuwa o hlaelang pela lekgotla o tshwanetse a hlalosetse lekgotla mabaping a melato e ileng ya kgaba lekgotla empa le tla batla go tseba gore na moqosuwa o na le katlholo tsa gale kgotsa o na le melato e mengwe e a tshwanetseng a e tsamaele pela lekgotla wa hlalosa gore melato e kgadiweng ga ona mo e kenang teng le gape mosekisi o la botsa kgotsa a bua ka yona melato e kgadiweng e robong maikemisetso a gae e na le go senya dipina mo setšhabeng ka dintlha tseo kaofela di bopaki bo tlisitsweng wa hlalosa gore ga gona molao le o thibelang gore baqosiwa ba lokolle ka pele di ka dintlha tsotlhe tse a di tlisitseng o bontshitse gore tsamaiso ya toka e dumela tokolo ya baqosiwa ba le bararo gore ba tswele ka motle ba lokolle mo ditšhankaneng go fitlhela ba le ba fetsa go seka molato wa bona empa fa ba ka tswela pele ba dile ditšhankaneng di tla be ona kgethollo mo ditokelong tsa bona tlasa molao Thank
you. Mr.
As it is the court. Yoshi, before I approach, I wish to just explain how my submissions, the sequence of my submissions, Yoshi. I first plan to give a brief detail or exposition of the applicable laws in relation to bail applications, and then I move on to a brief explanation of the facts. By the facts I mean what led to accused 1, 2 and 3 to be here on the 5th of August 2024, and then I attempt to apply the the laws and the principles outlined to the facts to try and show this court that accused 1, 2, and 3 should not get bail, are not eligible for bail. Please go. Beginning with the exposition of the law, Your Worship, the starting point in every bail application is section 35, subsection 1, paragraph F of the Constitution, which states that everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interest of justice permits, subject to reasonable conditions. This section of the Constitution is given statutory effect in Chapter 9 of the Criminal Procedure Act 51 of 1977. Thus, Section 60, subsection 1, paragraph A of Chapter 9 of the Criminal Procedure Act 51 of 1977 states that an accused person in custody in respect of an offense shall be entitled to be released on bail at any stage preceding his conviction in respect of such offense, unless the court finds that it is in the interest of justice that he or she be detained in custody. Therefore, from the above, it appears clearly that the power to grant or refuse bail is essentially a judicial one, and that the court will lean in favor of liberty and grant bail where possible, provided the interest of justice will not be prejudiced by this. Put simply, bail may not be refused unless there are sufficient grounds for believing that the accused will fail to observe the conditions of his bail. Section 60, subsection 4 of the Criminal Procedure Act provides that it will not be in the interest of justice to release an accused person on bail where one or more of the grounds listed in paragraphs A to E are present. Such grounds include A, where there is a likelihood that if released on bail, the accused will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense, or where there is the likelihood that the accused, if he or she were released on bail, will attempt to evade his trial, or where there is a likelihood that the accused, if he or she is released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, or this is D, the preceding one was C, this one is D, the subsequent one, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. And lastly, E, where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace and security. Now, Your Worship, the state submits that in this current application for bail before this honorable court, there are several factors which indicate that almost all the grounds listed from paragraph A to E above are present, and therefore it would not be in the interest of justice for any of the accused persons to be granted bail. Bishop, for convenience, I wish to refer to them as accused persons. I understand the applicants, Your Worship. I don't want to confuse myself. Okay, and then moving on to the next point in law. As it is common cause between the state and the defense that this is a Schedule 5 application for bail, Section 60, subsection 11, paragraph B, shifts the burden of proof, and that the point of departure, owing to the charge or charges preferred against the accused, is that it will not be in the interest of justice for any accused persons to be granted bail unless such accused person can show that, or rather can show by way of evidence to the court that his release on bail will not undermine the interest of justice. Thus, evidence must be produced by all accused persons that if released on bail, it is unlikely that they will endanger the safety of the public or any particular person, or commit a Schedule 1 offense, or attempt to evade their trial, or rather not even or and attempt to influence, or rather, let me just start again. The first one, it is unlikely that they will endanger the safety of the public or any particular person, and it is unlikely that they will attempt to evade their trial, and it is unlikely that they will attempt to influence or intimidate witnesses, or to conceal or destroy evidence, and it is unlikely that if released on bail, they will jeopardize the proper functioning of the criminal justice system, including the bail system. And lastly, it is unlikely that their release will disturb the public order or undermine the public peace and security. The state submits that no sufficient evidence was led by any of the accused persons which can lead this honorable court to the conclusion that none of the sections, or rather none of the section 60 subsection 4 paragraph A to E considerations are likely to materialize should the accused person be granted bail. Now, moving on to the facts of the case, Your Worship. As we all know that there's video footage circulating in social media everywhere, be it Twitter, WhatsApp, Facebook, where it is shown that accused number 1, accused number 2, accused number 3 entered a primary school in the township of Katlehong, wherein accused number 1 was wielding machetes, 2 machetes or pangas. Accused number 2 is believed or is seen there with a rifle, what may be perceived or understood to be an AK-47. Accused number 3 is seen dragging 2 kids out of an office building in the premises. Now, firstly, in the state's affidavit, it's indicated that there were 2, there's video footage, there's another video footage which may not have gained such popularity as the first one, but then there's a video footage, the state is in possession of a video footage showing that accused number 1 also had another rifle in his boot. Took out that other rifle, he is seen discharging that rifle to disperse people who were in public, or rather in the streets, so that he can drive and leave the crime scene. Now, Your Worship, that place where they were is a primary school. Kids there, Your Worship, just to put things into perspective, some of the kids there a few months ago were in nursery school crash, Your Worship. And it is seen that accused 1, 2, and 3 were carrying AK-47 in front of crash kids who were in crash a few months ago. Just last year ago they were in crash. Some of these kids have never seen a gun before. Some of these kids have never seen a machete before. But the video footage that is circulating indicates that they were exposed to that by accused 1, 2, and 3. Now, in applying the facts, Your Worship, in applying the law to that short piece of fact, Your Worship, section 4A, the question which needs to be asked as to whether it would be in the interest of justice for accused person to be released on bail is there a likelihood that if released on bail, accused persons will endanger the safety of the public or any particular person or commit a Schedule 1 offense? Now, the evidence before, or rather, which the state has, indicates that accused 1, 2, and 3 have no permit, have no license to carry rifles, Your Worship. These are wartime weapons. They carried wartime weapons at a primary school, Your Worship. Now, one rifle was taken, or rather located, and was taken away from the accused persons. The other one, which was in the boot, has not been located by the police. It's still with accused 1, 2, and 3. So meaning they are still in possession of an unlicensed firearm, which is concealed somewhere. I don't know where, because we don't know where accused number 1 lives, judging by his multiple premises that he gives. So, Your Worship, the question that the court needs to ask itself is, will release or on bail of accused 1, 2, and 3, will it not endanger the safety of the public, Your Worship? These are people who have the brazen audacity to go to a primary school with guns, rifles, AK-47s, and expose kids to AK-47s. And there's another gun that's still circulating amongst them that hasn't been located. If the court releases accused 1, 2, and 3, and they have, and furthermore, Your Worship, this also has to be emphasized, they are not skilled to be carrying AK-47s. They have no permit, they have no license. They never went to training to carry AK-47s, and yet they went to a primary school unskilled to carry AK-47s and put the lives of primary school kids in danger. These are the people who want to go out on bail, who still have a rifle that is illegal circulating somewhere. So, Your Worship, in the state's view, Section 60, subsection 4, paragraph A has been met, Your Worship. There's a likelihood that if released on bail, there's actually more than likely they will endanger the public, Your Worship, especially given the fact that they've got that boldness. So accused number 1 is prominent relatively. Knowing that people are taking video camera, video footage of what he was doing, his antics there, he still nevertheless went ahead. I mean, he was so brazen. So if a person is so confident and audacious enough to commit a Schedule 5 in public, what more a Schedule 1 in private? I mean, you might as well just committed it anytime. So, Your Worship, in the state's view, these are dangerous people. They will endanger the safety of the public. Releasing them on bail will prejudice the interest of justice, Your Worship. It's not in the interest of justice that accused 1, 2, and 3 be released. Now, as having given the facts, Your Worship, I move on to Section 4. Your Worship, just to state not only the facts, but factors and considerations which emerged after accused persons have been arrested. The first one being that for purposes of bail, they had to give their residential addresses to the investigating officer so that that can be verified, so that should they be granted bail, they can be easily pinned down to a particular place, and the court can, or rather the state can know where they are should they not come to court. They can just go there and arrest them. So these are considerations which emerged after they were arrested. And 1, 2, and 3 provided details pertaining to their addresses and where they reside. And 1 and 3 said they reside Gumete Street somewhere in Albemarle. And they gave that information to the investigating officer saying, we reside Gumete Street, there's a name, there's a number, it's given, Your Worship, it's on record, Your Worship, as I was reading the affidavit. There's a house number given, the street name and the area, Albemarle. The police went there to go verify the address, only to find that that place doesn't exist. Doesn't exist whatsoever. And actually, that place is a complex. Well, Albemarle, that suburb, where it's indicated, it's a suburb. As they went there, the security guards, before even going inside, the security guards told the investigating officer, listen, there is no Gumete Street here. I've been working here for some time. There's no Gumete Street. However, the investigating officer still said, you know what, let me go there and check for myself. Drive around using scarce state resources to drive around looking for a street that does not exist, only to find that indeed that street doesn't exist. And so we still currently don't know where accused 1 and 3 reside. Accused 1 has a tendency of he's been before courts on criminal or in relation to criminal matters several times. The affidavit indicates that it's about 9 times where there's been cases opened against him and such matters have been withdrawn. However, and furthermore, in those 9 times, he's given 9 different addresses. And now his son vouches for him, or accused number 3, in a way vouches for him and says, no, actually I'll also live where my father lives, at a non-existing address. So, we don't know where accused 1 and 2 lives, accused 1 and 3 lives. Accused 2 initially said, I live in Boksburg, Marbleton, Boksburg. When the investigating officers went there, yes, there is a place like that, Marbleton. There is a house number that's in line with what he gave the investigating officer. The neighbor confirmed, he wasn't there, the neighbor confirmed that yes, indeed, such a person resides here alone, which is also a bit of a concern. If a person lives alone, it might be a little bit too easy for him to just locate and be untraceable. However, now in his affidavit, I note that when he gave where he resides, he gave a different place now where he resides. Instead of saying I reside at Marbleton as being the person, as being the place where you had gone as a state to confirm as being my residential address. Now he comes and says, no, I reside at number 3 Garfen Avenue, extension 2, Albemarle 1401, at the place of my employer. The same employer which we do not know where he lives, who's got several addresses, and last week Friday, I don't know why the foresight of giving another address. On the same day, he gave another address, gave the court another address. So he's been giving several addresses in his track record. Now, accused number 2 says, no, I reside with this person who's giving several addresses. So now, coming to section 4, or section 60, subsection 4, paragraph B, which indicates that it would not be in the interest of justice for accused person to be released if or rather where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Now, a proper interpretation of section 60 subsection 4 paragraph A is given by way of having regard to considerations which are enlisted or listed under section 60 subsection 6 of the Criminal Procedure Act. No one really knows where he lives. Sure to say, but then let me not say it. The extent to which the accused can forfeit the amount of bail. Your Worship, the state submits that accused number 1 is a man of means. As it is known, he's a prominent pastor. He can afford to forfeit the amount of bail which this court can give. The question whether extradition of the accused should be readily effected. Your Worship, when it comes to extradition issues, Your Worship, it's quite an issue, and furthermore, Your Worship, the nature and the gravity of the charge on which the accused is to be tried, the strength of the case against the accused, and the incentive that the accused may have to evade his trial. Now, when it comes to the gravity of the offense, Your Worship, that is borne out by the fact that unskilled to carry wartime weapons, accused person goes to a primary school and exposes children to danger. That's the gravity of the offense that the accused person is facing. Apart from all the other offenses, there's assault, there's kidnapping, which is also a very serious offense. And the state will show, in fact, that firstly, we're not bound to be proven beyond a reasonable doubt that there is kidnapping, but there is evidence, Your Worship, indicating that there is actual kidnapping. The applicant, or rather accused number 3, brought in an application with the children's court in this building for custody of the kids, and he gave the address where the kids reside being the grandmother's address, and the court understood that those kids should be residing there at that address. The accused number 3 knows very well that those kids, the court has made a temporary order that they should be residing where they are until pending the finalization of the custody dispute. He knows very well he was not supposed to take those kids. He took those kids against the court order. Now he comes in and he says his lawyer goes on and on about having the right to have custody over the kids. The issue of custody is still an issue before the courts, and those kids were placed at a particular place, and he knows very well where those kids are, and he went against the court and took those kids forcefully. So the custody, or trespassing, or what you call it, what's the other charge? Kidnapping charge. There's evidence. But moving, I was just sidetracking there. Coming to the law, the gravity of the offense. Your Worship, it's obvious, Your Worship. It stands to reason that these are serious charges. The strength of the case, the evidence is out there for everyone to interpret. The state has bureau footage. There's as the state was reading out the affidavit opposing bail by the investigating officer, he gave descriptions to several witnesses who are willing to testify before this court and tell this court during trial what transpired on the day. There's video footage, there's eyewitnesses, several eyewitnesses. Now the state has a strong case, has a pretty much open shut case. So that would give accused 1, 2, and 3 an incentive, Your Worship, a very strong incentive to evade trial. I mean, they themselves, it's not a speculation. You know, sometimes when people attend court or for trial purposes and their trial start, they speculating as to what evidence the state has. You know, some of them think, you know what, maybe they don't have that much evidence. In this instance, Your Worship, everyone knows, everyone who has a phone, everyone who has social media knows the state's case. And apart from that, in addition to the state's case as it is known in public, there's additional video footage the state has showing further criminal conduct, clearly indicating that there's sufficient, strong evidence against 1, 2, and 3. So much so that they may be motivated by the threat of a likely term of imprisonment to evade their trial. Therefore, Your Worship, RSA submits that Section 60, subsection 4, paragraph B of the Criminal Procedure Act is applicable to the facts of this case and all the considerations which have emerged thereafter to indicate that should accused 1, 2, and 3 be released on bail, there is a likelihood that they may evade their impending trial, because no one really knows where they stay. The strength of the state's case is enormous, Your Worship, virtually insurmountable. It's not in the interest of justice for them to be released. Moving on to Section 60, subsection 4, paragraph C, which reads, where there is the likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Now, Your Worship, in accused 1, 2, and 3's affidavit, the accused person indicated that, indulgence, Your Worship, I will not interfere with state witnesses as I am not aware of the identity and or details. I am not in possession of evidentiary material or evidential material. Now the state submits that this is not true. This is a willful attempt to mislead this court by the accused persons. Because firstly, at least 2 of the state witnesses, Your Worship, as indicated in the affidavit, at least 2 are related to the minor kids involved in this issue, as the grandmother of the minor kids and the aunt of the minor kids. And furthermore, accused 1 and 3 are also related to these minor kids from the paternal as well. Maternity and paternity, there's a relation to these minor kids. Now, for accused person to, and furthermore, in relation to the assault and the intimidation charge, these witnesses that were listed in the investigating officer's affidavit, they are complainants, Your Worship, in relation to 2 charges at least. They are actual complainants regarding the intimidation charge and regarding the assault charge. For accused number 1 and 3 specific, especially, to say we don't know who the witnesses are, it's a fabrication, Your Worship, and it's willful, Your Worship. They are not telling the truth. They are misleading this court. They know very well who the witnesses are, and they know where they reside. So as to the evidence stated there were 2 rifles. What has been confiscated from accused persons is 1 rifle. There's video footage of another rifle, which is unlicensed. This other rifle is evidence in relation to the possession or without the proper appellation, forgive me, Worship, unlicensed firearm, possession of unlicensed firearm. That's evidence for that count, and other counts. There's evidence, and that evidence is still in the possession, not physically, but accused 1, 2, and 3 know where that evidence is. They can, if they were released on bail today, they know where to go and conceal or destroy that evidence. So it would not be in the interest of justice for accused 1, 2, and 3 to be released, and they do not seem to be people who are willing to assist the state in the investigation of this matter, because they have not provided any information as regards to the whereabouts of that firearm or rifle. So releasing accused 1, 2, and 3 on bail, in view of the fact that they know the witnesses, they know them personally, they have a relationship. In fact, Worship, Section 40 subsection, or rather Section 60 subsection 7 indicates that giving a proper interpretation of 64D, or rather 64C, some of the factors to take into account: whether the witnesses have already made statements, the relationship of the accused with the various witnesses, and the extent to which they could be influenced or intimidated. There is a relationship, Your Worship. Although the accused number 3 was not married to the family relation or rather was not married to his girlfriend or the deceased girlfriend, the state submits there is a relationship between accused 1 and 2 to the 2 witnesses stated in the affidavit, Your Worship. So, Your Worship, the state submits that Section 60, subsection 4, paragraph C, Your Worship, vitiate against this court granting accused persons bail, as that would be not in the interest of justice, Your Worship. And now moving on to Section 60, subsection 4, paragraph D, which reads, where there is the likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper function of the criminal justice system, including the bail system. Your Worship, interpreting this provision, Your Worship, the Criminal Procedure Act enjoins us to go to Section 60, subsection 8, and to consider certain factors, Your Worship, thereunder, amongst which include the fact that the accused, knowing it to be false, supplied false information at the time of his or her arrest or during bail proceedings. Okay, that's one of the considerations to be taken into account when interpreting Section 4, or Section 60, subsection 4, paragraph D. Now, and as an indication, or rather, as to whether release on bail will undermine or jeopardize the objectives of the proper function of the criminal justice system, or including the bail system. Now, Your Worship, the state has already mentioned that accused 1 and 3 gave false statements before to the investigating officer as to where they live. They they pretty much concealed their residences to the complaint, to the investigating officer. So they gave false information, knowing it to be false. The state submits, knowing it to be false. For you can't give an incorrect residential area when you know that place does not even. You can't give a residential area that you know does not exist. Every one of us, if anyone asks me quickly where you live, I'll give them directly where I live. I will not think twice. I will not speculate or come up with false places and areas where I live. Accused 1 and 3, just in fact, what transpired, the investigating officer saw that what accused 1 and 3 did, they took street from the church and combined it with Albamali. The church is in Katlehong, Albamali is in Alberton. Combined the two together and said, okay, we live Albamali, Kumete Street. Kumete Street is in Katlehong, Albamali is in Alberton. Combined the two, created a false place and said, this is where we live. There's no, why they misled the investigating officer? No one knows. It's for them to know. And furthermore, they misled this court. They say, we don't know the witnesses. We don't know who are the witnesses. But I've just indicated that they know very well who, at least 2 of the witnesses. They misled the court there too. So these are people, Your Worship, who are prone to misleading. Well, not the court, but then they misled. They gave some misleading information in the process of this bail application. So these are people, Your Worship, who are prone to giving false information. How can they be trusted should they be released on bail that they will actually abide by the conditions and come to court on every time the court is postponed to another date? They are dishonest. They are dishonest people. How can they be trusted? State submits, they cannot be trusted. Bend of bail should not be granted. Furthermore, moving on to indulgence. Paragraph E of Section 60, Section 60, subsection 4, where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Well, Your Worship, the state submits that release of accused persons will lead to public disorder, Your Worship, and that there's already evidence, Your Worship, indicating that immediately after the events of the 5th of August 2024, accused number 1's property, being his church, was burned to the ground by an angry mob, angry members of the community, particularly at the school, in and around the said school. Now, it's evidence enough. It's not a speculation as to whether it will happen or not. There's evidence that it has happened before, Your Worship. And furthermore, Your Worship, they endangered minor kids who have parents, Your Worship. Those parents, Your Worship, are not pleased with, these are allegations, of course, Your Worship. But then these allegations are strongly corroborated and solidified by video footage that circulates, that they were at a primary school with wartime weapons. Parents of those kids I don't think they're happy with the situation as it unfolded on the said day. Given the fact that already there is this misconception in society, and furthermore distrust of the judicial process and so forth, Your Worship, by society, and now comes accused persons coming out on bail after they have threatened their kids at school, place where it is understood ought to be one of the safest places, because it is it should be a protected place. They went there with guns. As parents, I don't think they'll be happy if accused persons were to be released out on bail, Your Worship. And furthermore, in line, Your Worship, with that, I just want to read an extract from a Constitutional Court decision, Your Worship. This is S. Dlamini, the proper citation being a second edition, 1999, volume, or rather 1999, volume number 2 of the South African Criminal Records, page 51, in comma, 1999, 4th edition, South African Law Report, page 623, Criminal, or rather Constitutional Court, CC, where it is stated that, I quote, there is a widespread misunderstanding regarding the purpose and effect of bail. Manifestly much must still be done to instill in the community a proper understanding of the presumption of innocence and the qualified right to freedom pending the trial under section 35, subsection 1, paragraph F of the Constitution. However, the ugly fact remains, however, that public peace and security are at times endangered by the release of persons charged with offences that incite public outrage. This is the Constitutional Court acknowledging that releasing some people, some accused persons, if they were to be released out in the streets on bail, there'll be a public outcry, and that would incite public outrage to a point where what already transpired may transpire again, because Your Worship, in all likelihood, accused number 1 will still go back to his. I hear that his church has been restructured, new marquee or new tent. Accused person will go back into the very same societal community wherein he threatened kids. He threatened their livelihood, their well-being. He threatened them with AK-47. He'll be going back there, further inciting the community members therein to act, because they see here is this person who's done this and now he's out on bail. So therefore, Your Worship, the system submits that from paragraph A to E, there is a ground or another which has been established. This is paragraph A to E of the Criminal Procedure Act, section 60, subsection 4, paragraph A to E. The onus is upon the defense or the applicants. I heard my colleague saying the state has not alleged that any of these grounds have been. It's not upon us to allege. They're supposed to prove or disprove the likelihood of any of these grounds. Not one. They must disprove that not even one of them, not even one will materialize. Now, I have shown this court that there is a likelihood that all of them might materialize, Your Worship. And therefore, Your Worship, given that into account, Your Worship, and taking that into account by the court, the state is of the view that accused 1, 2, and 3 bail ought to be, bail application ought to be denied, Your Worship, and they ought to be kept in custody pending the finalization of their criminal case. And indulgence, Your Worship. Yes, Your Worship, those are the state submissions. Please open.
Thank you. I see the time is 1 o'clock. Advocate, let me know, would you want to have a right of reply?
Yes, Your Worship.
Are you going to be long, or should I adjourn for lunch and then come back?
Let's adjourn for lunch.
Back, Mr. Melagazi?
Yes.
Back at 1:45.
So to
Not 2 o'clock. We need to move. It's already in the afternoon now.
Yes.
The court then will take an adjournment for lunch. Back at 13:45. Mr. Melagazi, you have the affidavits, correct?
Your Worship?
Exhibits. Can I have the exhibits? You took the exhibits.
Oh yes.
All of them. Investigating officer, no, we have one.
Oh, here's another one.
And 2 for applicant number 2 and 3. Then 2? You don't have applicant 2.
Bishop?
No, applicant 1. Affidavit.
Oh, here's one.
Thank you. Alright, court adjourns for lunch.
Yeah. To go? Alright,
settle down. Thank you.
Kita hlalosa sene se buat ke musikisi a fana mabaka hlalosa gore ba ne a le khatimo mo rona ja ka ba thusiwa le le ka pedi ba hlalosa gore la ntlha mo le mongwe o na le tokelo go fa fetsa o khatimo a lo go le ka pedi ha ba le tsamaiso ya toka e dumelana le tokelo ya hae le hape wa hlalosa gore ba mosebetsi wa ja ka thusiwa o fana ka mabaka Lupa, buat harus sama dengan kita. Itu hanya cerita yang hal apa ini, masalah sama. Ya kami lawan ini yang mana kita selalu itu hanya cerita sesuatu kita kalau kita dekat kami dan kita kait sana kalau khususnya apa kalau kita bebas dari nak khususnya bakal kau dia sebab hati kita bisa membahas bersama dengan anda berkhususnya dekat susah sebab ini bapak kalau mereka berkhususnya sebagai bangsa anda berkhususnya kasih lagi melawan anda berkhususnya kaya sakor pesan dari konsol masih cari apa kalau itu lagi kasih cari ya dua kali sakor kamu pagi ini kasih di sini kemudian itu kasih hal kaya salah nak kalau suatu terus cari kabarnya pada pagi kasus salah pagi pada siapa satu ini melawan ini hampir pasti konsol masih cari file kali ini dia hatua apa salah ini ini saya kita mulai salah aku kalau satu video ada video ini seperti itu sampai kusua bagian sekolah usaha kalau satu antara sila kita kusua wanita anak cewek kawa orang tinggi anak cewek hati itu posisi usaha itu aku rasa yang ada bagaimana ada kabarnya kali bikin loya bersama usaha kato ya bapak di mana dia punya dia ini itu yang dia kamu pakai musik atau Imoen kuzua wanita yang lawan anak atau orang itu ansas punya hati laksana itu ini kita tahu bahwa patah anak kalau mana sila yang awal dia dia hati wasalusa bagaimana solusi bagaimana awal dia hati kunci itu belajar masih bagaimana bagaimana kunci dia penyebab kalau wana itu sebenarnya panga kamu kusua basi ini diona he abona sama bakal sesuatu kaya sana kok ini dia kusua malukulah apa sudah bilang salusa horuna dapat kusua awalnya itu pemain tapi ini naniona jauh sama situasinya dia habis sisi sama lagi dia Cuma situasinya lah sisa Postponement sabana bakanyimani ya kuwahlalisa lo kita alungena unalizithunya tsembili ephatana manibali ulufumana isithunya sesingosi sesinsabubili abathina osika sesihlalosa khusuwa wanthani ukhusuwa amubili bafikela isi okamabonisa bupati babatawusibikisana kobasekisa ngolatuba khusuwa lona le hape wa hlalosa gore e nngwe ya dintlha go ka shebang gore a nna ba tlosiwa e ka nna batho ba ba kotsi mo setšhabeng a re eya kwa etsala gore go be jwale gobane lona le le tshwere AK-47 le hape ga ona tokomane e bontshang gore lena le tokelo ya go tshwara le hape a la rupellwa kgotsa le na se diriswa go tshwara sethunya se se tshwanang sa mofuta oo empa ebile a tswela pele a tshwara sethunya seo a sona sekolo sa bana banyane le hape wa hlalosa gore mokgosi wa bantlha ke motho ya tsebahalang setšhabeng sena le apana bona batho ba merekoda ka founu empa seo sa mo thibella gore a tswele pele ka boitshwaro ba hae o la tswela pele sa botlhoko gore batho ba mo tseba le hape ba mo thola le hape wa hlalosa gore mefuta ya diweapon tse di tshwere panga le sethunya ke diweapon tse di sebediswang haholo ke masole le dikele a se diweapon tse tlwaelehileng ba tswela pele a hlalosa gore morago ga gore le tshware moqosuwa o mongwe wa lona o le wa hlalosa le fane ka address la fa maponeseng le hape lona kaofela lona le bararo la fana ka address la hlalosa gore la lefelo le losi ko Alvamari empa le maponesa a na tsamaya a lo shebisisa address eo le netefatsa gore ke nnete ba le ba fumana gore address eo ha e pele go tsamaya lefelo le a leo le hape ba le ba netefatsa ke ma security badisi ba lefelo leo empa ba tswela pele ba batlisisa ba senya nako ba senya tšhelete ya mmuso o batlana le lefelo le seo le hape ba netefatsa gore a o tsamaisela metsamaiso ya toka gore baqosuwa ba lokolle gobane lona a la fana ka address ya nnete seo se tlhalosa gore ga ona motho ya tseba gore dula kae le aparela bonnete ba gore le ka se baleng fa le ka le hape fa a shebisisa moqosuwa wa ntlha le makgetlo a robong a ntse a tlamela kgotleng le hape o fane ka diaterese tse robong tse sa tshwaneng se tlhalosa gore nna o ntshitse a le motho o senang nnete ba le fane ka diaterese tse fapaneng tse robong le hape go tlhalosa moqosuwa o mongwe ena wa lona la magareng a lona wa bobedi la fana ka aterese ya koposoke ya komaletse le hape ba ile ba ya maponisa di baagisane ba netefatsa gore ka nnete motho ona o teng ditafane empa o dula a le monosi yape wa tlhalosa gore motho ha dula a le monosi o bonolo gore a sa fumaneng kgotsa a nyamalle a sa tlhaile pela botlotla fa ba ka molokong le hape wa tlhalosa gore ka botlalo le dintlha tse kaofela di kopanisa gore bona rena bonnete ba gore dula kae le hape ba tlhalosa gore mabapi a bokgoni ba moqosuwa wa ntlha kgotsa madi kgotsa tšhelete e a nang le yona o ka etsala gore a sa kgopela pela lebatla fa ba ka molokolla ka beili le hape wa tswela pele a ba tlhalosa gore moqosuwa wa boraro e le mora wa moqosuwa wa ntlha a na tseba gore ile wa ntshiwa lekwalo kgotsa melawana e leng ya bewa ke lekgotla e ne tlhalosa gore bana ba hae kgotsa diboholo tsa bokgolo tse leng bana ba dulang lena ba tshwanetse ba dule le bokgolo mmogo fitlhela moqosuwa wa boraro a ba fetse go seka moolo empa moqosuwa na se tseba seo a ka se fela tseo a tswela pele a lo nka bana ka go sebedisa maatla a sa fumana tokelo ya kgono e leng ena o ile a fiwa tokelo ya gore a dule le bana go fitlhela moqosuwa wa boraro a ba fetse go seka moolo a ba tlhalosa a tswela pele gore lona ke gale le fana ka information e seng ya nnete mabapi a di-address tseo di batla ke lekgotla go netefatsa gore ba tla le fumana empa mabapi a go nna le fane ka address e seng tsa nnete sena se le bontsha le le batho ba senang nnete le gape o ka etsala gore le ba le sa kgotla la molao fa ba fetsa go lekolla wa tlhalosa gore le gape o ka se le kgotso mo setšhabeng gobane wa iponagatsa gore kereke ya moqosuwa wa ntlha ile ya beswa ya phediswa ka mollo go bontsha gore o ka se le kgotso mo setšhabeng fa baqosuwa kgotsa moqosuwa wa ntlha a ka lekolla ba tswela pele go na le footage e leng ya bontsha lona fane ka lokolla le le bararo ba le botlhobane le gape ba tseba ba ka etsala gore ba thusetse ka dintlha tseo tsotlhe kaofela le mo bona tsamaiso ya toka e sa dumele tekolo ya lona o bona re botoka wa lebile ditšhakane di fela ha di fetsa o seka molato o tlhalwa
Thank you. Yes, Advocate Lamine.
Sorry, Your Worship. Your Worship, there's a point, a vital point, Your Worship, which I missed,
I'll allow you.
Your Worship, as indicated that in the affidavit, the kids, Your Worship, the two kids in this issue are pertinent to the case, Your Worship. The state still doesn't know where they are. No one from the state side knows where those kids are, and the state feels that to release accused persons out on bail after surmountable evidence which indicating that it's kidnapping, in the state's view, back to those children, which would not be in the best interest of the children.
Yes, Mr. Poyana.
Thank you, Your Worship. I do not intend wasting...
Mr. Lamine, wait. He needs to interpret that last aspect by Mr. Vilakazi. Did you listen to? Were you listening?
Yes.
Just interpret the last aspect made by Mr. Thank you. Lamine.
Thank you, Your Worship. I did not want to waste your time, but the last point raised by my brother needs me to refer the court to section 21 of the Children's Act 38 of 2005. Just read it, Your Worship. The heading is Parental Responsibility and Right of Unmarried Fathers. That's the heading. 21, in bracket 1, the biological father of a child who does not have parental responsibilities and right in respect of the child in terms of section 20. And it makes it nice. Section 20 gives specific fathers a parental right. Section 21 specifically addresses the parental responsibility and rights of unmarried fathers. Emphasis there. Acquires full parental responsibilities and right in respect of the child. Full parental responsibility and right in respect of the child. There are subsections. Subsection A, if at any time of the child's birth he is living with the mother in a permanent life partnership. The state has already confirmed, Your Worship, that they were staying together and that right exists. B, if he, regardless of whether he has lived or is living with the mother, consents to be identified successfully applies in terms of section 26 to be identified as the child's father or pay damages in terms of customary law. Your Worship, those issues will be tested in a correct platform. But the first point it has given The third applicant undisturbed full parental responsibilities and right in respect of his children. That is law of this country. What disturbed me, Your Worship, my brother here did not argue, he was testifying. He testified that there is a interim court order, but that interim court order is not mentioned in the police affidavit, is not mentioned, is not even brought to court, just a hearsay. Most of his submissions, Your Worship, it was just him testifying. The children has not been denied that they are with his father. And that's the reason why the interest of the children is that their father must be released in prison. The allegation of kidnapping has no basis. Here is the law telling you any other person that wants to remove this right must approach the court, and the court must grant that right. And they have to satisfy the court why these children should be removed from their father. That's the position of worship. That's a legal situation. And unfortunately, my brother did not address it. That's the position of this country, right of children. We are proud to say that for the first time after the constitutional democracy, children rights were taken into care, and the Constitution has put in a right to that. Your Worship, the Children's Act was enacted to fulfill the section of the Constitution. I've already submitted earlier, Your Worship, that neither the police nor any other person can change that law. Only the court has the power to remove children from their father and give it to any other person who can look after the interest of the children. That is the position, Your Worship. Some of the issues raised, I won't never even try to go to them. My brother here raised issues that are not in the statement of the policeman. And in short, he was just giving a hearsay testimony. There is nothing that has been placed before court that it definitely will necessitate this court not to grant bail. Nothing. it seems as if prosecution rely on the so-called withdrawn charges, different addresses. Your Worship, what is important in what prosecution is saying there, it does not say that in those 9 withdrawn charges, the first applicant or the first accused failed to attend court sitting. Nothing. In those 9 charges, there is nothing says that the first accused was a threat to community. May I just look at my beautiful, nice pocketbook and address each and every point that my brother tried to address. In the 9 alleged withdrawn cases, potent signal that there is nothing saying that they were withdrawn because the accused has failed to attend court, that the accused endanger the safety of the public or commit Schedule 1. For B, where there is likelihood that the accused is or she, were released on bail, will attempt to evade his or her trial. There is nothing. It does not help the prosecution because whatever they say, the accused or the first applicant attended until they withdraw those charges. It's not in his liking or made for the charges to be withdrawn, except if the police try to say some of their people are not doing their work. If they are not doing their work, it's not the problem of the accused. C, where there is likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses. Nothing that is said on those 9 alleged withdrawn cases. In fact, those work in favor of the accused because there is nothing that says he did not comply with the requirement of section 64 in bracket A to E in bracket. D, where there is likelihood that the accused, if or she were released on bail, will undermine or jeopardize the objective of proper functioning of criminal justice system, including bail system. There is nothing in those 9 alleged withdrawn cases that the accused failed to comply with bail orders. Nothing. E, and I like E the way it's captured, where in exceptional circumstances, there is likelihood that the release of the accused will disturb the public order or undermine the public peace or security. Nothing. In all those alleged 9 withdrawn cases, There's nothing that says he did this. He did this. Your Worship, I have already submitted that the state did not contest what the accused or the applicant has put before court. And the only contestation is this document. Nothing that is not here could be pushed to this court. You're putting it back door. The issue of interim court order, they try to smuggle it in back door. There's nothing. They will have talked about it in their police statement. They tell us about the videos, Your Worship, and they selectively talk about specific videos that they talk about. There are many videos circulating talking about the incident, even the burning of the church. There are many. They don't talk about it. And who actually was there? There are videos showing who was there. It's circulating, it's public knowledge. And in this case, they talk about a weapon that they have not even brought to court to say that we have this particular type of weapon. They rely on what is the video. Your Worship, any video is subject to be what is the pronunciation? Authenticated in order to be admitted in court. We cannot just rely on something that somebody is talking about without knowing where it comes from, who took it, how, or was it doctored or not. That's the position, Your Worship. Videos, hearsay, all what they were putting before you, Your Worship, is just a hearsay. We have handed over a municipal statement proving residential of the first applicant. They keep on running, talking about a different address and different things. Your Worship, what is important is that do we have a fixed address for the applicants? If yes, Your Worship, they complied with that requirement. And there's proof of it. Unfortunately, the desperation result in desperation action. What the prosecution was trying to do was an act of desperation to try to nullify what is obvious. What is obvious is that the third applicant is the biological father and the law grant him the rights. If they can give me any other rights, then I will understand. But as for now, before this court, there's only one issue. It is the Children's Act that gives this court guidance. I have, Your Worship, given you case law. And my brother mentioned Dlamini. I like it. I like that case. It actually favors the applicant. That is the importance of that. There is no case law that will go against a simple, straightforward situation of a bail. A bail is a right, it's a constitutional right until where the court is satisfied that there is a danger. Without that, we have satisfied the requirement of bail, and the court, if it likes, it could set conditions. Those conditions are there to mitigate about what the state fears. Those are the conditions. It's clear. The case line I've given, it talks about it. To say when the issue of a bail is an important constitutional issue, not just a right, it's a constitutional issue that must be protected at any way. That right, the court is required to protect that right. It is the duty of the court not to keep people in prison unnecessarily because satisfying some egos or some people who want to settle scores. This is the position, Your Worship, that there is a point. I have already alluded that the children are not going to school. We have never denied that we don't know the whereabouts of the children. They can't go to school because his father or their father is behind bars, and their rights are affected. We have set common cause with the state that those children are not well. There's no dispute about that. And as long as the father is behind bars, the life of those children are at risk. I once, some years ago, Your Worship, I was a trade unionist. The mother of the child was detained in Tembisa, and when I took care of the child, and the police wanted me to hand over that child, I said, prison is not for children. I cannot take a child to prison. Prison is for the criminals. And the whole world agreed with me. The mother was released to look after her child. There are certain things that you cannot compromise. You cannot compromise because the police want the children, because they are police. When the law is clear, who must take care of the children? Your Worship, I have said enough. I do not want to waste your time. Oh, I'm reminded of this issue of AK-47. Your Worship, that falls in the trial. That is an issue of the trial that will deal whether there is such a thing or not. It's an issue that has been brought up as if people have never been released on bail, having been involved in Schedule 6. Have been released, Your Worship, not 5, 6. Worst situation. When they satisfy the requirement of Section 64 in bracket A to E. Now, all this allegation, Your Worship, is to try and create a situation where the court will be confused in coming with a correct decision. Unfortunately, that's not the case. The court first is the guardian of the minor children. So the court will have to take interest of the minor children. Secondly, the court is the protector of our Constitution. Our Constitution regards the accused as innocent, no matter how strong the case or weak the case. The court should look at the interest balance the interest of law and the interest of the accused. The court should avoid playing into the gallery, public gallery, where because it's Pastor so-and-so must be kept in prison, denying him all his constitutional rights. We died for this constitutional right. We fought for them. We cannot compromise them, because those are the rights that come from the blood of our people. It doesn't matter whether it's Pastor Mboro, the constitutional rights must be respected. Can I approach Your Worship?
Yes, you may.
That concludes my submission.
Thank you, Katlehong.
Muso ba ile ba netefatsa ka nnete mme wa bana ba bana se se bontshang gore wa bana le le mokhusi wa bona o na le tsone ditokelo tsa a dile bana a ba komele le hape a ba bua mabapi le dintlha tse di le ba bua ke mosebisi gore o la bua ka interim order wa wana mo tutswana o la hantsiwa ke le khotla na se makatsang gore seo a sa kwala o affidavit ene ya sekolosi na ditlatse ba di ke sa bona go affidavit tsa kone ka la bukane le tlhaya na isa le hape ba ka se motho a ise khoswa go da ba ba ke le pamana go ba le lawa ke ona o motuleng ke ndo le mai ka go a o hlokomela na go ba ke ena ntse wa ba na ha yena wa hlalosa gore go tla ke lona fela le na le matla o fa motho go tswa mo la matla ya mo ke la ditokelo tseo ke lona go tla fela le na le matla ya ba tsela pele a hlalosa mabapi a ditlhale ba di district mosebisi wa hlalosa gore mosebisi o tshepetse haholo mabapi a melato e re mo e leng ya kgala ya mokhusiwa wa ntlha empa ka mo madimabe mo melato e re mo e kgabile ha ona sepe se ile sa bontsha gore mokhusiwa wa ntlha o ile a leka go balia a sa gale go tlotla ya ona sepe se se bontsha gore mokhusiwa wa ntlha o ile a ba motho o go setšhabeng kgotsa fane ba fetsa go mo lekolla la tsona e etsa e nngwe fa ba fetsa go lekolla le hape ona bopaki bo mosebisi a bo tlisitse go bontsha gore mokhusiwa wa ntlha o melatong e re mo e le a tloswa yona le kwa sa tsena a tlhagelela le go tla ile a ba motho a sa lefelele na ngwana kgotsa motho o leng a thusetsang baki le hape wa tlhalosa gore dintlha tse dingata tse mosebisi a diile ga di a kwala mo affidavit ke bopaki ba wa tlhalang go tlabola la go tlhala jeno jaaka molawanile wa tshwa a Motsoeneng e le interim order kgotsa video e le ba re e tletse le hape wa hlalosa gore ba tshepetse mo bopaki mo bongata mo ba bo boneng ko video empa ha ona motho o ile wa netefatsa nnete ba video eo ka mo he yona o bona go tlhalisa a mo jaaka bopaki ona bonnete ba gore ke a bonnete e video e ba bua ka yona empa bona ka mo hlakoreng la bona ba hisitse lengwalo la masepala go netefatsa kana ya address o bontsha mo le ka fumane ya tiro fa ba fa le ka lokolla ke ka ho na a sa hlalohanye baneng tse le bua ka ditaba tsa gale mo le mokhusiwa a na fana ka address tse di la ya khatsi ya bona a ba tswela pele a bua mabapi a ditokelo tsa bana a ba hlalosa gore o kgetholle mo ditokelong tsa bana kgotsa go latelle mo ditokelong tsa bana gore ntate wa bona a dile ditšhankaneng le gape ke lona lebaka le etsang gore bana ba sa kgone go tswa thuto ao ba ya sekolong ke gore mosebeletsi wa bona kgotsa ntate wa bona ba ntse a kwaletse ditšhankaneng ke ao le jalo o kgetholle ditokelong tsa bana le mo ditokelong tsa moqosuwa wa boraro mabapi le taba ya sethunya sa 1847 ha ba tla kenela ho yona a itse o tla bua ka yona a se ba qadile ho seka molato tena go tla se bua kgotsa se motho se kana ho seka le hape o kopa ba go tla le shebisise ditokelo tsa bana ba nahanele bana gore ke eng se tla sebeletsang bana go tsena go pele ba hlalosa gore ka dintlha tsohle tsa dikisitseng le bopaki o bontshitse ka bopaki o o bo feletseng gore tsamaiso ya toka e emela tokoloho ya pele bona gore bona gore lona le tsone ka mantlha ka pele fitlhela le go fetsa ke se ne se bua ke mo le
Mr. Ponyana, I'm going to read, then you, when I pause, you. I'm saying I'm going to read, and then I'll pause, then you interpret.
Okay, we're doing it.
Okay. All right, then the court is about to deliver judgment in this matter. It's case number DC2/2022/2024 in the matter between Paseka France Motsoeneng, the first applicant, the second applicant being Vincent Camelot Baloy, the third applicant being Revival Motsoeneng. This is the state. There is a bail application brought by the applicant before this court. It is imperative to note that this bail application was on the roll of District Court number 2 next door, and due to last-minute logistical and heavy court roll of District Court number 2, the matter was placed before this court. The application commenced at about 2 p.m. on Friday, the 16th of August 2024, and the court noted the displeasure of the defense that the state was deliberately delaying the said matter. Mr. Vilakazi is appearing on behalf of the state, and the counsel for the three applicants is Advocate Lamini. The state is opposing the bail and that it is a Schedule 5 bail application. It is common cause that the applicants before this court are charged with 12 counts of various offendings ranging from kidnapping of minors, 2 counts of assault by threat, 1 count of assault, possession of prohibited firearm, 3 counts of discharging of a firearm in a built-up area or any public place, 2 counts of pointing of anything likely to lead a person to believe it is a firearm, 1 count of malicious injury to property, and 1 count of possession of dangerous weapon. The various offences were allegedly committed on the 5th of August 2024 within the court's jurisdiction.
ka selo se se shebanang ka sethunya melato e kgotsa diketsagalo tse la kaofela di etsahetse ka di-5 tsa August 2024 mme lefelo le nana le kgotlana.
Now, it is tried law that the applicants are entitled to be released on bail if the court is satisfied that the interests of justice permit their release as envisaged in Section 60, Subsection 11B of the Criminal Procedure Act. This section informs us that the court shall detain the accused until they are dealt with according to the law, unless the accused adduces evidence which satisfies the court that the interests of justice permit their release.
e ka tsamayang le mabaka le bopaki bo bontshang gore tsamaiso ya toka e dumelana jwang le tokomane ya rona ya pele hobane ha o se jwalo e hloka gore kgotla ya kgotsa le ya ka molawana le dule ditjhankaneng ha ba ne la hloleha ho bontsha mabaka a bontshang gore tsamaiso ya toka e dumela jwang tokomane ya rona.
The applicants submitted the affidavits in support of their bail application. In the affidavit, they detail their personal circumstances and confirm that they intend to plead not guilty to the charges. The applicants' affidavit were confirmed and signed by them, and they were handed in and marked Exhibit A, B, and C, respectively.
le hape makwalo ana a boikanyo a ile a nkiwa jaaka bopaki bo tshwarelang ke lekgotla kgotsa Exhibit A, B, and C.
Applicant's number 1's personal circumstances was read onto the record. He states that he is a pastor at Incredible Happenings as well as director of Incredible Happenings Trading CC. He does not have any previous convictions and or any pending cases or any domestic violence order or harassment orders against him. He stipulates that he is deeply rooted in the Katlehong region and he has children. One of the children of the accused number 1 is accused number 3 in this matter. He further in his affidavit states that he has employed 30 people from whom depend on him for their living. As a result of his continued detention in custody, he will severely prejudice the said employees. Further to that, he informs the court that he financially contributes to the upkeep of his grandchildren, as the church which he is a pastor of has employed applicant number 3, and as a result of his detention, the best interest of the children will be affected. He can afford bail of 3,000 rands. Applicant's 2 personal circumstances were also read onto the record. He is the bodyguard of the first applicant. He has no previous convictions, has no pending cases. He has no domestic violence orders, protection orders against him, no harassment orders against him. He states that if he fails to provide services to applicant number 1 as a result of his detention, his employment will be terminated. He can afford bail of 500 rands. Applicant's 3 personal circumstances was also read to the record. What the court can gather from this affidavit is that he is the father of the 2 minor children who are referred to in count 1 of the kidnapping charge. He has no previous convictions, no pending cases. He has no domestic violence order, protection orders against him, or harassment orders against him. He submits to the court that his 3 minor children need him as they depend on him. He informs the court that he is a widower and his continued detention will not be in the best interest of the minor children. He can afford 500 rand bail. In all their affidavits, they stated that they addressed all the provisions and or factors that are listed under Section 60, Subsection 4 to 9 of the Criminal Procedure Act. That was the applicant's case, and they closed their case. Now, the respondent provided a long bail application affidavit. It was deposed by the investigating officer. It was read onto the record. I will not repeat same, but only provide a brief summary of the day of the incident. The captain states that in addition to the above mentioned offences, there is also a charge of trespassing and contravening Section 21A of the Private Security Industry Regulation Act 56 of 2001. According to the investigating officer's affidavit, there seemed to be an incident that transpired on the 1st of August 2024 before the main incident being the 5th of August 2024. The investigating officer submits as follows from paragraphs 8 to 9 of the said affidavit that there were accused number 3 had taken 3 minor children from the school without informing anyone, and this necessitated assistance of the police, who attended to the property of accused number 3 and 1 and then the property of accused number 1, which they were not found. Now, on the 5th of August 2024, one of the witnesses who is employed at the school where the minor children of accused number 3 attend and where the said alleged offences transpired, found the said minor children in their respective classes. The said minor children informed the witness that their father, accused number 3, accompanied them to school. When school times had concluded, accused number 3 went to collect his children, and this is when the scuffle and chaos erupted at the said school. It is stated in the affidavit that the deputy principal attempted to contain and resolve the said impasse, but was unsuccessful, and an unpleasant scene therefore erupted and or started. The witness observed that accused number 1 had 2 pangas, or machetes if you can say, which he used to intimidate and threaten individuals who were on the scene. Accused number 3 was pleading with the deputy principal to release his children into his care. It was at this point, as the witness describes, that accused number 1 gave accused number 3 one of the pangas, and he forcefully opened the burglar gate and removed his children and left the school premises. Accused number 2 is described as the individual who was carrying a firearm described as a rifle. The investigating officer submit that a witness was pointed with a firearm described as a pistol by accused number 1 as they were exiting the school premises. This was when it was observed that accused number 1 was instructing one of the witnesses not to record the said incident. They entered into the vehicle of accused number 1 and drove away. The witness also states that they heard gunshots before all 3 accused drove off. The investigating officer states that the maternal grandmother of the 2 minor children did arrive at the school premises upon her other daughter, who went to collect the minor children, informed her that accused 3 had taken the children forcefully. She is one of the witnesses who claimed that she was assaulted by accused number 1. The investigating officer further states that after the first court appearance, which was the 6th of August, he went to view the video footage where he observed the said vehicle of accused number 1 and him discharging a firearm in public, and the said firearm is not the same as the same firearm that was in the possession of accused number 2 when the incident happened. Paragraph 10 of the investigating officer's affidavit is key-worthy to note that it offers explanations of the accused's physical addresses, which will be expanded upon below. The investigating officers then individually provided information about the respective applicants before court. This is their personal circumstances, their criminal history, etc. And applicant number 1, the investigating officer is opposing bail on the basis that the applicant's residential address is negative and that there's no number 2027 Gumede Street in Albemarle. Therefore, accused number 1 offered an incorrect address, which will thus be impossible to trace. The other view that the investigating officer holds is that the accused number 1 is concealing other firearms that have not been recovered by the police, and as such, this poses a danger to the witnesses and the community. The investigating officer states that accused number 1 does not have any previous conviction or pending cases. However, in his profile, he has 9 cases that were withdrawn. He tells the court that accused number 1 was the instigator of this incident and is a danger to society, more so to the witnesses and the maternal grandparents. He further opposes bail in that this incident was widely publicized on all social media platforms and has shocked the community. He further submits that the accused are in danger, as accused number 1 is a prominent pastor, and subsequently of this incident, his church was set on fire and burned down as a result of the community being angry and unimpressed with the conduct of accused number 1. Applicant number 2, the investigating officer is opposing bail because his address has been verified and he resides alone in Boksburg and he can evade his trial. He further submits that he's a danger to society as he does not possess any licenses for the firearm he had in his possession and that he can easily access unlicensed firearms. Applicant number 3, the investigating officer is opposing his bail in that he provided incorrect address, therefore he has no fixed address. That was the respondent case and no further evidence was presented. The investigating officer's affidavit was handed in and marked Exhibit E. Now, in deciding whether applicants are candidates to be admitted to bail, the court needs to clarify certain issues. Where the applicant has discharged the owners under Section 60, subsection 11B of the Criminal Procedure Act. Another aspect is that the court has to consider is whether the applicant successfully passes the factors listed under Section 60, subsection 4A to E, as well as Section 60, 5 to 9 of the Criminal Procedure Act. Now, the court would like to make it clear that it is not the duty of this court to determine the guilt of the applicants before this court. That's for the trial court to determine. What is of importance is that it's for the court to weigh up the evidence before it and provide a value judgment whether on a balance of probabilities have the applicant before this court successfully discharged the required onus placed on them.
le hape le kgotla le tla batla le ele hloko gore se mosebetsi wa lekgotla lona le fumana nna le molato kgotsa le sena molato ke seo se tla etswang mo tlase ka ntho kgotsa lekgotla la o se ka molato empa mosebetsi wa lekgotla lena ke o shebisisa dintlha kaofela tse hlokegang gore a na lona jaaka baqosuwa le se le fane ka bopaki mo kgotsofatsang gore lekgotla le ka qeto le ka bonang gore tsamaiso ya toka e dumela kgotsa e kgatlhanong le tokelo ya lona ka pele.
Now, the right of an accused to apply for bail, it is found in our Constitution, Section 12 and Section 35, 1, D, E, F. They expressly protect this right to apply for bail. In the case of S versus Japan, it states that the right of an applicant to apply for bail and the urgency thereof is important, but equally important are the rights of the public and the complainant as well.
S versus Japan, which is
the court has to look at the factors listed in subsection 60, subsection 4A to E of the Criminal Procedure Act, but not in isolation, as these factors must also be read in conjunction with section 60, subsection 5 to 9. These are factors to determine whether indeed the applicants are or do qualify to be admitted to bail. The court is also mindful that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. The court will quote, I see Mr. Dlamini quoted it from S versus Diale. The court will quote the same quote from S versus Swanepoel, which says that a court cannot find that the refusal of bail is in the interest of justice merely if there is a risk of or possibility that one or more of the consequences mentioned in subsection 4 will result. The court cannot grope into the dark and speculate. A finding on the probabilities must be made unless it can be found that one or more of the consequences will probably occur. I turn now to look at the facts presented. The applicant before this court submitted affidavits in support of the release on bail. The court must disappointingly note that all three affidavits was a cut and paste of one of the other with only varying differences, as the respective personal circumstances can never be the same. I must also note that the said affidavits were littered with unnecessary spelling errors. There was not much great care and skill taken when the said affidavits were drafted. Case in point, the said surnames of applicant 1 and 3 are different to that of the surnames on the charge sheet. Now, there is a clear copy and paste of the criminal procedure sections, which the applicants must elaborate and discuss in order to show that they are candidates suitable for the release on bail, but they failed to do so. The investigating officer gave a detailed and comprehensive bail affidavit. In the affidavit, the court was given a clear picture of what transpired on the day of the incident. It is also tried law that hearsay evidence is admissible in bail proceedings, and that bail process is sui generis in nature. Basically, anything goes in a bail application because of its uniqueness. Now the court has to weigh up all the factors and decide on a balance of probabilities to determine whether applicants can be admitted to bail. The case of S versus Shititak encapsulates this reasoning clearly, which basically states that bail proceedings are sui generis in nature. The state does not oblige in its turn to produce evidence in its true sense. It is not bound by the same formality. The court may take into account whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future holds. It must be prognostic to do this. It must necessarily have regard to whatever is put by the state in order to decide whether the accused has discharged the onus placed on them. Now let's look at applicant's number 1, affidavit. It is common cause that he is a prominent pastor and his church is very well known. It was also not disputed that the said incident was publicized on national television and on social media. Applicant number 1 simply gives the court nothing other than to place his circumstances on record. He does not thoroughly explain the impact of his incarceration. He only informs the court that he is responsible for 30 employees and that his church members will suffer spiritually if he is not released. He does tell this court that his mother will suffer as he financially provides for her needs and medical needs. He does not explain how he was arrested, nor explain the charges that he faces. I touch on the manner of how he was arrested because the investigating officer in his affidavit submits that the J50 warrant was executed in order to arrest applicant number 1. It is common knowledge that a J50 warrant is applied for when a suspect is wanted and cannot be located at their respective residential address. This, the court believes, is also one of the important aspects that applicant number 1 should have thoroughly ventilated in his affidavit. He does not explain that this incident was recorded and therefore causing a social media frenzy. He does not explain that on the day of his bail application having commenced, which was the 16th of August 2024, his church had already was burned down to ashes, as the investigating officer informed the court. Applicant number 1 simply gives no effort in addressing the factors which would enable him to successfully discharge the onus placed on him. The court disagrees with the investigating officer that applicants 1 and 3 do not have fixed addresses. It is unbelievable that an individual of the stature of being applicant number 1 that he possesses will not have a fixed address. It is clear that the address on the said charge sheet was incorrectly spelled. Applicant number 1 and 3 provided an address by submitting a rates and taxes account from the municipality, which was handed in and marked Exhibit D. I do agree with Mr. Vilagazi when he says that the 2 addresses were combined, because 2072 Gumeta Street is in Katlehong, and then the address that's provided by the applicants before this court, the one in Geffen Avenue, is in Albemarle. So it's clear that the said address was combined. Therefore, that's why the investigating officer could not locate it in Albemarle. Furthermore, it is the submission of the investigating officers that the police officers, they went to applicant's number 1 residential address on the 1st of August, 4 days preceding the main incident. So that surely confirms that the address is indeed positive and was verified. Mr. Vilagazi made submission that the previous cases of applicant number 1, he gave different addresses. This cannot be a basis to state that he does not have a fixed address. Even for applicant number 2, the investigating officer cannot come and tell this court that just because applicant number 2 resides alone, he is a flight risk and can evade his charge. His address has been verified, therefore the court holds no issue with the addresses of applicants number 1, 2, and 3.
lebaka la gore mokgweetsi wa bobedi o dula a le mo notice a se hlalose gore yena o tla baleya fa ka lekgotla la lekgotla ke ka gore lekgotla le yona le a amogela address ya mokgweetsi wa bobedi le wa ntlha.
Applicant number 2's affidavit also provides this court with nothing. Personal circumstances are on record, and that is as far as the affidavit goes. He neglects to fully canvass the provisions that are of importance in determining whether a candidate is suitable to be admitted to bail under Schedule 5 offense. Applicant number 2 fails to address the issue of him being a good bodyguard and whether he is registered by the applicable authorities to become one. He does not dispute that he holds no firearm license, and he does not dispute that he was on the scene of the incident. All he gives to the court is that he intends to plead not guilty.
ditokomane tsa sebedisa tsa sebetsa jaaka sebetsa ana ona le tsona kgotsa ana tsona na ona le tokelo ya ho tshwara sethunya ele ya dintlha tse di ngata tse ba mo tlhosa tsona ha ka hlalosa mabapi a gore yena ba ne a sa dumelane le tsona ona le dintlha tse di ngata tsa sa bua ka tsona e leng dintlha tse bohlokwa pele ga lekgotla le yona le thuseye le qeto mabapi a gore
The investigating officer also submitted that applicant number 2 was brandishing a firearm which was described by the witnesses as a rifle. The court cannot ignore this point. I now turn to applicant number 3. Now, in as much as applicant number 3 gave a sloppy affidavit which does not tell this court much. Case in point, he says he is a widower but does not provide proof to this effect. The investigating officer's affidavit comes to his aid and assists applicant number 3. The investigating officer gives a background of why the said incident transpired. The investigating officer also does not mention much apart from him opposing bail against applicant number 3 in that his address is negative. I have concluded above that the court takes no issue with the addresses that they have been verified. Now, Advocate Lamene, counsel for applicant number 3, correctly points out that applicant number 3 does have parental rights and responsibilities as protected in Section 21 of the Children's Act. There is no court order before this court that states otherwise. The 2 minor children have only one parent, and that is applicant number 3. To deny the applicant number 3's right to take care of his minor children will be an injustice to the end. This court will not go down that route. Now the investigating officer provides a picture to the court of what exactly happened on the day of the incident. What is also worth noting is that the investigating officer suggests that it would be beneficial for the accused to be kept in custody as a measure to protect the applicants before this court. The affidavit is clear that there is an outcry and displeasure of the accused's conduct to have a prominent pastor commit such a heinous act in the presence of minors, which he ought to have protected as he is their grandfather, has left the community angered. So much so, as the investigating officer stated in that the applicant's number one's church has been burned to ashes. This is indicative of the anger of the community. Perhaps they could as well be paying for his blood. The affidavit of the investigating officer also shows that there are too many witnesses who were subjected to this ordeal, and what could also not lose sight of the fact that this incident occurred in a public school where minor children are enrolled at such school. The conduct of the applicant may as well have left the witnesses and learners traumatized. Now, Section 28, subsection 2 of the Constitution tells us that the fundamental point that the best interests of the child are of paramount importance, and as such, it is the duty of this court to protect children and ensure that they are protected in the environment where they receive education. This is not only in respect of the two minor children affected by this incident, but by the learners of the said school where this incident transpired. To be brandishing dangerous weapons and firearms in an environment and institute of learning, this the court shuns the behavior of such. Now, in the case of S. vs. Shabalala, it was stated that the court must assess the appellant's future conduct in the light of existing or historical facts and circumstances. I cite this case in support of the factors listed in section 60, subsection 4A to E of the Criminal Procedure Act. This, the court then must balance the right of the accused and those affected by the incident. Did the applicant discharge the onus placed on them? Do they satisfy this court with the evidence that they have placed before this court with the affidavit that they are suitable candidates for bail? Now, the only thing that this court must do is just to make sure that it's satisfied that all three applicants before this court, they can attend their bail, their case before this court. This is not the duty of this court to determine the guilt of the accused, as I've said. That's for the trial court to do. Now, it is quite unfortunate that the affidavits presented by the applicants before this court were not satisfactory, and simply they were just not giving of anything. The onus rests on them to demonstrate that they've adduced evidence that which are in the interest of justice to permit their release. The court has considered all angles and dissected the affidavits, and simply there is no indication that the said onus was discharged. This court is a creature of statute, and it does not operate on emotions and no influence. It is not a reactionary court, but simply deals with the facts presented before it. It is a creature of statutes and does not have inherent jurisdiction as that of the higher courts. So it simply can only do what is permitted to do within its own legislative framework. If the applicant fails to discharge the onus placed on them, then it is therefore clear then what should follow as a result thereof. The applicants did not have an obstacle of discharging the higher burden found in Schedule 6 bail applications. They simply needed to demonstrate to this court that the interest of justice permits their release, as opposed to the higher test found under Schedule 6 bail application. Their affidavits do not dispute that they are linked to the offenses preferred by the state. There is a strong case against them, and frankly, they did not put up a fight in ensuring that the evidence submitted by them hold enough water to discharge their owners. Now, I have expressed above that the investigating officer comes to the aid of applicant number 3. It is clear that the investigating officer has no reason why he is opposing the release of applicant number 3, and in the circumstances, the court must do what is fair and just. Applicant number 1, 2, and 3, please stand. Now the court ultimately looks at what is presented before it, and it provides a valid judgment from the said evidence. This court is persuaded that this case consists of so many probative factors which tips the scale in the respondent's favor. Now, in considering all the evidence before this court, the evaluation of the factors listed in Section 60, subsection 4 and 5 to 9 of the Criminal Procedure Act, applicant 1 and 2 have not discharged the onus that rests on them and have not adduced any evidence which has satisfied this court that it is in the interest of justice that they be admitted to bail. Applicant number 3, there is no basis that he should be detained up until the finalization of this matter, and therefore the court shall grant his release from custody.
wa boraro ga ba bontsha kgotsa ba kgotsofatsa ka mabaka le bopaki bo bontshang gore tsamaiso ya toka e dumela jwang tokelo ya bone ya pele ke ka hoo he go ka le dumela ya bona empa kgosuwa wa boraro kana ga mothosuwa wa boraro maponisa kgotsa maponisa a fana ka mabaka a tlhalosang baneng ba le kgatlana kopo ya hao ya pele ke ka hoo he kopo ya hao ya pele se a dumela empa wena mothosuwa wa ntlha wa bobedi la fana ka mabaka a kgotsofatsang gore ka lekana ka pele kgotsa a bontshang gore tsamaiso ya toka e dumela jang tokelo ya ka metsi ao maposo wa ntlha wa bobedi wa hanetswa kopo ya lekana ka pele wa boraro ya dumela.
So then the order is as follows. Applicant number 3, you are released on warning with the following conditions. You are to have no direct or indirect contact with the witnesses of this matter, save for the maternal grandmother and aunt under the guidance and assistance of the Children's Court. You are prohibited from entering the said school premises where this incident occurred up until the finalization of this matter. The court is aware that this condition, it will impede you exercising your parental rights and responsibilities, but this is only until the finalization of the matter, alternatively the outcome of the Children's Court matter. You are therefore warned to appear at the Knox Court date, and failure to do so, you may have your release on warning cancelled. And therefore applicant number 1 and 2, your application for bail is hereby denied.
Children's Court ebe sa melawana ba batla molato o tsamela mane khosuwa wa ntlha wa bobedi ona tlhatlhelwa le tlhadula ditšhakane go fitlhela le benefits tsa go seka molato tlhalo a tsebo.
Mr. Vilakazi, date?
No.
Date?
The court, or rather the state, is begging Ms. Court's indulgence, or should that maybe the state be granted a period of 2 months for the investigations, stop ballistics, outstanding, and so forth.
I don't know. Then the date with the defense then, it will be for investigations, correct? The date, Advocate Dlamini?
Mr. Chairman?
That is too low. Your Worship, that's too low.
I don't know.
I understand, Your Worship. However, we're going to be in the same position, because if we get a shorter remand, we're going to ask for postponement again for further investigations in any event.
How many?
Your Worship, 2 months. Accused number 1 and 2 in prison. That's completely situation where they are denied.
But the state is saying that they still need to investigate. And I'm sure with ballistic report, we know the situation at our criminal laboratories, that there's a backlog there. So surely that ballistic report is going to take quite some time. Hopefully it will be sped up.
Can I consult?
You may.
Your Worship, we will accept the state proposal, but we need a date.
Yes, you must provide me the date. Look at your diary and let me know.
Okay, indulgency. The 21st of October.
What day of the week is it?
Monday.
Is it suitable, Mr. Dlamini?
It's suitable.
Gentlemen, you'll then appear in District Court number 2. That's the reception court. On the 21st day of October for investigations. Accused number 1 and 2. Since your bail has been denied, you shall remain in custody. Accused number 3, you are released on warning with the condition that was set before this court. You are warned for 8:30 District Court number 2. If you don't come to court, a warrant of arrest will be authorized against you. 21 October, DC2, 8:30. I want to advise the gallery the court is still sitting with other matters, so if you're going to leave, please leave quietly. Yes, that's what I wanted to say. The court is still sitting. I've got other matters to proceed with. So if you're going to leave, please leave quietly. Are you off record? I don't know if they're still recording, so let's wait.
Your Worship.
Yes,